Good morning, good morning, good morning. Did I post the wrong link everywhere and just fix it? Yes, I totally did. Is that to be expected all the time? It's Tuesday, it's August 15th. I recorded the behind the scenes podcast with the members only on a story a lot of you have been asking me about. So don't worry, we're going to get blindsided tomorrow on the podcast while I'm on a plane. What could possibly go wrong? Everything could possibly go wrong. So that's the podcast for tomorrow. For today, we are doing something that's going to be just a little bit lighter because why not? I mean, at this point, Netflix is trying to rehash the Depp versus Heard trial. I have really tried to move on, but the members had asked so much. So all of you that are excited for this topic, go thank the members on the YouTube channel and Patreon because we did a members only live stream covering a number of the sidebars. And we had a really good time doing that. And I learned quite a lot. So we are going to do more of that today. We're going to take a break from the murder. We're going to take a break from everything else. We're going to go through some sidebars. We're going to talk about what it's like to be a trial attorney. We're going to talk a little bit about Depp v. Heard. Not really. I haven't seen the Netflix documentary. I've seen articles that mention my name connected with it. I did not work with Netflix on it. I don't know if they've used clips from my YouTube channel. I don't know what the documentary is. I cannot recommend, not recommend. I don't know. We're going to see. I see people already frustrated about it. So I've seen some commentary where people are like, great. I've seen articles saying that it is a recontextualizing of the trial. I don't know why the trial needs to be recontextualized. If you watched it and formed an opinion, I don't know what else you need, but maybe it's a conversation. Maybe it's a conversation about social media. But again, can't people choose for themselves unless we're all just really being manipulated by the media and they don't like that we're not following their narrative? I don't know. We'll see what happens. Am I going to watch it? Not immediately. I got a bunch of shit to do. I am busy. So I'm on a plane tomorrow. I am not streaming on Thursday. I know. If you want to know when I am especially when my schedule gets lawneralert.com. It's a free email list. International, our text crew, we are working on a new solution because it is not international. And I know so many of you are. So lawneralert.com. We don't sell your info. We don't spam you with emails. I fucking hate emails. I just want to tell you when I'm live so you know what to expect. That's all. That's it. So Law Nerd Alert will keep you posted. I am going to stream on Friday. When on Friday? I don't know. It depends on the day. I have a few obligations, but I am going to stream on Friday. Friday, I am going to be streaming all of the evidence hearings. Well, not evidence here. Well, sort of. All of the hearings from Idaho. Here's the thing with Idaho. Idaho does not stream contemporaneously. Idaho lets it be recorded while the hearings are going on and then streamed after. So sometime on Friday, after those streams are available, or after those videos are available, I will be covering the hearings in Idaho sometime midday Friday. What we are going to see is the defendant's motion for a stay. We're going to hear the prosecution's objection to the stay that's already been granted. We're going to hear a lot about the DNA and what needs to be turned over and what hasn't been turned over and the rest of it. So that's all going to happen on Friday. So even though there is not a stream on Thursday, we will stream Friday. I am recording other things in studio on Friday. Doing that always causes me vast amounts of anxiety. Traveling causes me anxiety, doing new things. Like, I am an adult and it still stresses me out. I am sometimes in awe of my children. Like, you forget how much as you're growing, you have to like tackle new things that are unknown. And as an adult, I'm like, into the unknown? Fuck me. I want to go to the same restaurant I always go to that I really enjoy. Try something new? What if I'm disappointed? Then I've like wasted my time and my money, and I'm disappointed. Nope, 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 nope. Nope, nope. Could I try a new place to get delicious strawberry boba? Yes. But is the place I go to super delicious and good? Yes. And if I go to the new place and get strawberry boba and it's not the same as my favorite strawberry boba, then I'm just going to be disappointed and need to go to the other place and like replace the memory and get the good strawberry boba, and it's just too much. So no, I just stick to the place I like. I'm basic in that way. I mean, and many more. And many more. I'm basic in that way and many more. So with all of that, today we're going to just revisit a familiar topic, shall we? We're going to just have a giggle at these sidebars. Let me roll the intro and then recap what we did on the last sidebars. For all of you in the chat that are asking about the Michael Oher situation, there is a link for my YouTube short that I just put up about it. If you follow me on Instagram, I put it there as well. At some point, I will probably remember to put it on TikTok. No promises. I put things on Instagram first and then on YouTube shorts on my Quick Bits channel. If you are curious about that, I go through the whole thing on tomorrow's podcast. I go through the entire filing, not a lawsuit. I go through the entire filing. I go through the past filings. I kind of dug through the court website and grabbed everything that I could. So I will go through that tomorrow. Angie Lewis, members only vid question. Do you need to be a member here on YouTube or Patreon? Either one. Either one gets you to the members only videos, and either one allows you to participate in the members only videos. So I think you guys are ready for the sidebars, right? I think you are. So let's roll the intro. I'm going to tell you what sidebars we've already covered, give you a recap if you're a member or a new member, or if you've been gifted a membership by B2 and everyone else who is so generous gifting memberships. Then you can go find those on your member tab. You can watch all the past lives. It's the most recent live stream. So let's roll the intro. Tell me where you're coming in from, what you're drinking. I know I'm cutting back on Starbucks, I swear, after this round of travel. No, that's a lie. Emily, after pumpkin spice goes away. So pumpkin spice arrives at the end of the month. When pumpkin spice goes away, when pumpkin spice goes away, we're going to dial it back. But then if we get Irish cream cold brew, after that, we will like really step back to once a week. I make no promises during pumpkin spice season. I'm trying to reduce my trips to Starbucks. Here's the thing. My whole like morning plans and routines have changed because of my kiddos and school and stuff. And once I'm already out of the house, it's like Starbucks isn't close to my house. So so in the summer, less Starbucks, because it's like, there's a lot of inertia that needs to happen to like get out of the house and get to Starbucks. But like, I have to take my kiddo to school, and that's like more than halfway to Starbucks. So then it's just like, I'm already like halfway there. We're halfway there in my head every day. Oh, I survived the carpool lane. I deserve a treat. This is not health and wellness advice, but once you've survived the gauntlet of the drop-off line, it feels like I should just maybe roll through and get a Starbucks. So that's what I'm drinking this morning. Desperately waiting for the pumpkin cream cold brew to come back. Desperately waiting for that. And it'll be here by the end of the month. And since I'm traveling to LA, there will be Oletto, which I actually very much enjoy. So I feel like there's just no cutting back right now. We're leaning in for the moment.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
You guys, I love seeing where you're coming in from. I realized my phone as it's ringing is not on Do Not Disturb. That's distracting. We've got a wild George in here today. George has been the most connected cat. He's just like, his human is back at school, and now he's like, hey, who's at the house now? So now that his human is back at school, I think we will see more from the Pawnards. I saw a toast for a Pawnard. Hold on, I'm going to find it. Oh, Sweetie No said, I humbly request a toast to my recently departed Pawnard, to Barney. He was the goodest boy. To Barney, the goodest boy. May he be free with all the other goodest boys and girls, and enjoy. And Hope is greeted well by my beloved Albus, who years later, I am still not over it. The loss of a pet is unique and specific. It is different than a lot of other things. The loss of humans is complex and can be a lot. The loss of a Pawnard is uniquely and specifically tragic, and the absence is felt in a very unique and specific way. So to your Pawnard, I know we have had a lot of losses, and yesterday in the members only chat, though, we had some births too. So circle of life here in a in the Pawnard world. Don't worry, I will be taking breaks from the sidebars to get to all of our chats today. Charlotte, hello, Emily. How do we call the Audacity bumper? I think it's just a motion for Audacity. Just like we go for code red, code Audacity, code green. Because we're going to get the sass and the Audacity in these sidebars today. Let's talk about what a sidebar is and what I've already covered, shall we? Let's talk about that. So what we've already covered is all of the sidebars during Dr. Dawn Hughes's testimony. We got to relive the fact that Elaine called Dr. Hughes Dr. Curry multiple times, and we got to see exactly how much Elaine was struggling with the trial rules of evidence. At a deposition, things are a little more relaxed. At a deposition, you will make an objection. It'll be noted for the record. Then the answer will still come in, and then the court will decide it later, and you will get all of the things kind of onto the record. So for attorneys that practice mostly in depositions, it's a different pattern. It is much more flexible, much more lenient. When you are practicing in trial, the rules of evidence become very rigid and finite. I mean, they always are, but at deposition, it's like, we'll sort it later. At trial's the later. So trial is when it gets sorted, because it has to. At deposition, the only people that are going to hear the answers are all the lawyers, and it's a information gathering process. At trial, it is giving that information to a jury who's the ultimate finder of fact. And if it doesn't meet, the rules of evidence, it doesn't come in. And there were times I disagreed with Judge A's rulings. There were times that things I thought were hearsay came in. There were things I thought weren't hearsay that got kept out. There's always going to be that in a trial where you disagree with the calls the court made. But Judge A was consistent in the way that she made those rulings, and I think consistently made the same rulings to both sides. So I disagreed sometimes on both sides. It was like, ugh. But in the sidebars with Dr. Hughes, you could see Judge A explaining the rules of evidence over and over and over and over and over again to Elaine, who can't understand why Dawn Hughes can't just read her notes. She didn't want it to be a memory test. Can't just read her notes into the record. So Elaine is flustered, and Dennison, the expert, the attorney who dealt with the experts for Team Depp, was super frustrated. Because an expert can't just read their notes. Because the notes aren't evidence. What the expert did and knows is evidence. Notes can't really be cross-examined. That's why there's rules when documents come in, how they come in, how they have to be authenticated, blah, 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 blah. All the rest of it. But much like a spiritual witness, the report can't be cross-examined, just the expert. So there was a ton of fighting in the direct examination of Dawn Hughes about why she can't have her notes and why she can't snap back at the court. Dr. Hughes clapped back at Judge A. If you go back and watch it, you'll see it. a bit, clapped back at Judge A and was like, so I like look down and then look up and my memory's refreshed. It's like, what are you doing? I was dying. I was dying. So we covered Dr. Hughes' testimony. I also covered Eve Barlow getting yoted from the courtroom. Yeeted in past tense, I think. I don't know. Maybe not. Yeeted, yoted from the courtroom. I also covered the sidebars with regard to Gina Deuters getting yeeted from the courtroom. So when Eve Barlow got yeeted from the courtroom, it was very clear, and the judge made very clear, that Eve Barlow could not come back to the courtroom. Team Depp kept saying that Eve Barlow was the girlfriend and a journalist. Team Heard kept saying that Eve Barlow was a friend and supporter. So either way, the court, Eve Barlow from the courtroom. So all of that happened the day before where we're getting to now. Well, no. Well, yes. The Barlow stuff happened the day before where we're getting to now. The Deuters stuff happened numerous days before that. So today, we are picking up with the sidebars from trial day 15, May 4th. It is starting with the cross-examination of Dawn Hughes and then gets into Amber Heard's testimony and those sidebars. So cross-examination of Dawn Hughes. If you want to see the direct examination and the shit show of sidebars, that is in the members only video from this month. If you're a member, it's in your members only tab. If you want to be a member, you can, there's a thing down at the bottom where the super chats are. And if we get to a certain, Miguelina, pick a number. If we get to a certain number of likes on the video before we end, I will give away some memberships too, so you guys can go see it. How many people are here? 11,000? I don't know. I think we can get to 3,000 likes. You guys will have to keep me posted, and then I'll drop memberships in the chat too. We will make it rain memberships today. In honor of the fact that it seems that Netflix is going to go with hating everybody who covered this case, and cheers to us, I suppose. It's so funny to me. It's like, did you guys watch it? I saw a quote from somebody who's like, I guarantee that the people covering this case didn't read the entirety of the op-ed. I'm like, I read it a bunch. I guarantee you that everybody talking about me in particular did not watch my coverage at all. At all. They're just like, oh, she's streaming. Yep. And anyway, we'll get spicier if we need to. Miguelina said next goal is 5K since we already hit 3K. Let's do it. We're going to drop memberships now, and then we're going to drop memberships at 5K. All right, let me go do that real quick. Why is it? Give it to me. Oh, I know where I need to be. Okay, hold on. We're going to drop some now. We're going to drop some in a minute. Yeah, we're going to do both. All right. Hopefully this doesn't echo. Don't echo at me. All right. Only briefly. It only echoed briefly. All right. Let's drop some memberships, y'all, and then we will drop some more when we get to 5,000 likes on the video. Oh, yeah, we'll do 5,000 likes because I've already said it. All right. There we go. Let's roll with some sidebars. Emily, is your screen shared? No. Are we almost at 5,000? Well, we'll just keep upping it and we'll keep dropping memberships. We can do that. We'll just do that. We'll just do it. Why not? Then you can watch all the sidebars. All righty. Let's do some sidebars, friends. Oh, I meant to tell you something. Hold on. I'm going to sidebar my sidebar. I meant to talk to you about what sidebars were like and what they were. So there's a lot of things that can't be sorted out in front of the jury. And we saw some of it get sorted out in front of the jury in Depp v. Heard. We saw a lot of it go to sidebar. Sidebar, in most courtrooms, especially the more modern ones, they will have like white noise above the jury box, and they will play white noise above the jury box so they can't hear what the lawyers are saying. Some courtrooms, they will go sidebar into the back hallway. Some sidebars, they will excuse the jury to the jury room and just have the conversation in open court outside the presence of the jury. But there are some things where the attorneys need to argue, and arguing a piece of evidence that the jury's not going to hear could prejudice the jury because they're hearing all about it, and you can't unring that bell. You can't put the shit back in the horse. You can't put the toothpaste back in the tube. By that point, they've already heard it, and they're like, oh. And we're humans. Don't we all want the tea? And if they're talking about it at sidebar and then you don't see the evidence, aren't you kind of like, but what was that? Right? Different countries have different rules for this and different rules of evidence. And some countries that don't do jury systems, that have judges decide, they just let it all in. And then the judge weighs the credibility of witnesses, the veracity, all of it. So when lawyers go to sidebar, they are generally either dealing with unexpected issues in the court that the court needs to let them know about, i.e. a security issue or a juror issue, or they need to end early, or a witness called the court or something. Or they are dealing with rules of evidence and the lawyers are saying, Your Honor, this objection should be sustained or overruled for this reason. And then they're arguing about evidence over something that may or may not come in, a question that may or may not be asked, or something has just happened and they're like, Your Honor, we need a mistrial because this, that. So that's what happens at sidebars. Some trials have lots of sidebars. Some trials have very few sidebars. If you watch Depp v. Heard, you know that there were a lot of sidebars. One of the things that is so hard for me to watch is to not be involved in the sidebars because I was a trial attorney. I know that the goods are in the sidebar. I know that the information I want to know is happening up at the sidebar. And you could see these attorneys occasionally laughing with Judge A, occasionally you could see that the sidebars were not just bland. You could see the sidebars would get a little spicy, even if they were collegial. So I always wanted to know what was in the sidebars, and now we have them. So we're going to get through as many as we can today and go through those sidebars and these attorneys really sorting out this trial back and forth with the substantial amount of time that was taken for these sidebars. So we're just going through court transcripts today because. For those of you asking about memberships, the mods and Nightbot can let you know how to turn on your membership gifting. Make sure it's turned on. I will be gifting some more as we get to 5,000 likes on the video, et cetera, et cetera. We're close. We're going to be gifting more memberships in just a minute, and there's over 12,000 of you here. So you guys still want to talk about this case, don't you? Look at all of you. Look at all of you. Look at all of you. Can you always read the transcripts of the sidebars after? Only if somebody has paid for the transcripts. And in this case, multiple people paid for the transcripts and made them public. If they hadn't, I would have paid for the transcripts and made them public. Alrighty. Let's do the things. This is the very beginning of the morning, day 15, May 4th. All the attorneys are present. Bailiff, all rise. Court, all right, good morning. If I could have counsel approach for a moment. This is before cameras came on at the very beginning of the day. So at the end of the day, they just finished a shit ton of sidebars and Dr. Hughes's direct examination. We are now getting into Dr. Hughes's cross-examination. There was arguments about Dr. Hughes's notes and whether Dennis would get to see them overnight and prep the cross-examination, blah, 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 blah. Which is now a legal term since the Shabusiness trial, blah, 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 is now, a legal term of art. The court. This is the new PR guy. I don't know who he is. Who remembers the new PR guy that came into court in white shoes? Stark, bright white shoes. That's the only thing I remember about this PR guy. Social media excoriated the PR guy. I don't know if any of that's true or whatever. I remember him coming into court in bright white sneakers as the PR guy. Do you guys remember this? New PR guy. This is the new PR guy. I don't know who he is, but he just came through the back. You guys have heard me tell you stories about the back hallways of courthouses. Look, man, there are rules. There are rules in a courthouse. He just came through the back and was extremely disrespectful to my sheriffs, to my captain, to my lieutenant. Don't fucking do that. Don't ever fucking do that. Don't ever fucking do that. No. Even if the court staff is rude to you, do not be rude back to the court staff. If court staff seems like they are being rude, they've probably had some asshole in their face already this morning and hit traffic and had somebody park in their spot that was running late to court and thought that that was fine. Do not ever be rude to court staff. Court staff is the magic key to practicing litigation. And as a research attorney, I learned very early that the court staff is the all-seeing eye of the courthouse. They know everything. They know their judge. They knew who their judge likes and does not like. They know what attorneys are assholes and which ones are kind. They know who cannot stand up in court and give an argument, but will be rude over the phone. They know everything. And they are delightful. And they have to deal with members of the public and attorneys. This is not easy work, but to have entitled people come in every single day and be rude to them is just not going to fly. Court staff is bae. Get to know your court staff. If your court staff does not like you, practice in another courtroom. Just practice in another courtroom. All right. Very disrespectful. Because I told him he can't have his phone out. Sir, this is the day after the court is arguing about only the legal team being allowed to have their devices. Only. This is the next fucking morning that the PR guy rolls in and is like, what do you mean I can't have my phone? Are you the lawyer? No, the court made it so clear to the attorneys. So clear to the attorneys. I told him he can't have his phone. One of the deputies said he saw him with his phone out. Very disrespectful. I don't want him coming back. Now we know why the PR guy disappeared. This is Amber Heard's new PR person, because PR got fired and then there was a new PR person. This is the new PR person that came in and then got yeeted that same day. Literally the day after the judge lit into the legal teams, both legal teams, about who's sitting in the front row and who's having their phone out. The team that got in the most trouble was Team Heard because Eve Barlow had her phone out. Eve Barlow got moved from the front row that is supposed to be for lawyers only to the back of the courthouse, or further back where she couldn't pass up notes or hand her phone, and then had her phone out, was tweeting, and then got kicked out of the courtroom permanently. That happened like 12 hours before this. So Team Heard knew that this was an issue. And did they not give the PR guy a heads up? Like, this is conspiracy speculation, pure conspiracy speculation. Hey, lead attorney, good to see you in the chat. Pure conspiracy speculation. Did the attorneys not like the PR guy and just not tell him, hoping that the judge would be the bad guy and not them? Were they just like, you're on your own, boo-boo? Maybe there was discord between the team. You know, and they're just like, we'll let the court handle it. I saw a question in the chat. Why did she even have a PR guy? Both teams had PR. And I think both teams had PR present in court. Not surprising in a case like this at all. PR was monitoring the social media chatter and stuff, but maybe the lawyers didn't have the opportunity to talk to the PR guy. But PR guy gets yeeted before court even starts that day. I don't want him coming back. Yeah, you're not the lawyer. Kyle in the court said, Kyle in the court. Kyle in the chat said, conspiracy speculation. I'm stealing that. I stole it from Peter Mon. I'm also stealing it. Because it's not really a conspiracy theory and it's not really speculation. It's both. But maybe the lawyers just wanted the court to be the bad guy. It's not like we've never done that to a supervisor or a boss at work where we're just like, take it up with them. Let them be the bad guy. It's above my pay grade. And these attorneys, Team Heard, are being paid by insurance. Above their pay grade, perhaps, at this point. And that's still being fought over in court. We'll cover that next week. Miss Barlow does not come through security. I thought I made myself very clear about that. She does not come through the back. So Eve Barlow gets permanently banned from court, shows up to court the next morning with the PR dude, and comes through the back entrance. It's a surprising amount of chutzpah. And court orders are not to be messed with. And Judge A knows everything, right? She doesn't come through the back. Miss Barlow came through the back with Miss Heard this morning. Miss Bredehoff, oh, I didn't know. There's like 4 people in the courtroom at this point. You didn't see her walk in. She got banned from court yesterday. Elaine, I didn't know. I don't believe you, Elaine. I don't believe you didn't know. And if you didn't know, why don't you know what the fuck your client is doing, Elaine? It's your job to know, Elaine. The court, I don't care if you didn't know. This is a very bad start to the morning. I don't care if you didn't know, Miss Bredehoff. This is your responsibility. Oh, Elaine. Elaine's getting it from all sides. No wonder she was flustered on the record. She got yelled at before court even started. This is your responsibility. From now on, only Miss Heard, her assistant, and the insurance attorney comes back to the back. The insurance attorney. Elaine's firm and Rottenborn's firm are hired by the insurance companies. There's also an insurance attorney watching every single day of trial because the insurance companies are paying for this. They're now fighting to get their money back, but they were paying for this. Period. Judge A said, period. I said what the fuck I said yesterday. I am the judge. This judge must have been appalled that she banned someone from the courtroom. And they had the fucking audacity to not only come back to the courtroom, but to come in through the back door. To use special access because this is a high profile case. Period. If it happens again, I won't have anyone come to the back. Understood? We are making security accommodations for you, and you are abusing them. Ms. Bredehoff, completely understood, Your Honor. I apologize. Ma'am? How did you not know that Eve Barlow was in the car with your client? Eve Barlow was perma-banned from court. The court, I don't know his name, but he's very close to getting kicked out of my courtroom. If you want to let everyone know right now, I'm very upset about that. No one disrespects my sheriffs. Judge A is not fucking playing this morning. Ms. Bredehoff, I totally agree. Do you want me to go talk to him now? Elaine, how are you not comprehending what the court just said? Y'all, if we go code green now, we've got nowhere left to go. All right, you know what? Motion granted. Motion granted. Motion granted. And an air horn for the lead attorney if he's still in the chat. Motion granted. Because you know what? We're 2 pages into today. We're 2 fucking pages into this transcript. We're like 30 seconds of talking on the record into this transcript. The audacity. Okay. I have to make the lights green. Hold on. They always make me kind of green because I'm that. Where did I put my phone? Because I am that pale. We got to make the lights green. We got to make the lights green. I know. I got too excited about watching the bumper. It's new. I'm going to do it again. I need to set a complication or whatever to make the lights go green automatically. I just have forgotten to do it. I will do it. I just have not. All right. Let's make sure this one goes to green. All right. There we go. Green, green, green. If I start looking green, well, it is what it is. All right. We've gone green. which is not always an easy color to get lighting to do. It doesn't always like green. All righty. Green. George is like, what the fuck are you talking about, woman? He's got that face, like the what are you on about face. Miss Bredehoff, I totally agree. Do you want me to go talk to him now? The court literally just said, if you want to let everyone know right now, I'm very upset about that. The court told you what they wanted you to do, Elaine. And your response to it was, you want me to go do that? You guys, we hit 6,000 likes on this video already. All right. Somebody, we've got 15,000 watching. We need to set a new goal for likes and we'll drop some more memberships. So give me 1 second and I promised more memberships. And here they are. All right. The court, absolutely. Do we have anything else? Ms. Bredehoff, yes. The court, okay. Your Honor may recall that we talked about, and then Ben Shu cuts in. Your Honor, just to clarify, Ms. Barlow is not to come in the courtroom, correct? It sounds like Barlow is still standing in the courtroom while this conversation is going on. Mr. Chu, not to miss the moment. Just to clarify, Ms. Barlow is not to come into this courtroom. The court, correct. The court, no. She wasn't supposed to come in the back way. Ms. Bredehoff, she has been barred. The court, then she couldn't have come. Ms. Bredehoff, I agree with you completely, Your Honor. I completely understand where you're coming from. The court, all right, thank you. Ms. Bredehoff, so this is the rough transcript. This is now getting into the conversation regarding Dawn Hughes' testimony and what Dawn Hughes is allowed to be asked about on cross-examination. So now they are talking about whether or not Dawn Hughes is giving opinions outside of her expert declaration. Here's what that means. In the civil discovery process, which is a much more complex process than the criminal discovery process, criminal discovery is like, give them your shit. The end. Goodbye. Civil discovery has a whole bunch more rules, so you can't do trial by ambush because there are different rights involved. You don't have constitutional rights of an accused, etc. So you can't trial by ambush in civil, and there are cutoff dates. And if you miss the cutoff date for things, then tough shit. You've missed the cutoff date, and you're the one who has to suffer the consequences of it. There are very real discovery consequences for missing discovery deadlines or not putting things in your designations. So with experts, they have to say, it is my opinion that A, B, C, D, E, whatever. They can put in as many opinions as they want, but if it's not in their expert designation, they cannot testify to it. Even if on the stand they are inspired that that is now their opinion, too late, too bad, so sad, it wasn't in your expert designation. You have to tell the court what you are doing. And you have to tell the other side what you are doing. So this is now a continuing fight that Dawn Hughes is testifying to things that weren't in her designation. And she was allowed to testify to things that were outside of her designation. Did it benefit Team Heard? Probably some. Did it ultimately sway the jury? No. Ms. Bredehoff, this is a rough transcript. Your Honor will remember Dennison said that the witness had testified about IPV with prior relationships. Dennison was arguing that Dawn Hughes opened the door to allow him, Dennison, to question Dr. Hughes about Amber Heard's prior relationship kerfuffle at the airport, wherein there was an arrest that was later dropped. We saw that come in the rebuttal case, but they were trying to get into it at this point. And the court, I think, went above and beyond to keep that out at this time. And to make sure that that the court was not overstepping, that prior instance where it's alleged that Amber Heard was the aggressor in that situation, that Amber Heard being the aggressor in that situation should come in at this point. So I think the court did go above and beyond to keep that out. At the time, I didn't agree. I still don't know if I agree, but I think the court went above and beyond to protect Team Heard from this door being opened at this point, but the door ended up being opened later. George, a girl is trying to stream, sir. That cat, I swear. So Bretta Hoft is telling the court that this door should not be opened yet. This is not evidence that's coming in unless somebody opens the door for it to come in. The actual testimony she gave, and I've highlighted them in all of our copies, is she's talking about personality disorder. She said, and I'll let Your Honor read, the court is reading, quote, her emotional instability, her affect dysregulation, or her fear of abandonment is only occurring in the relationship with Mr. Depp, and we don't have evidence of it before, and we don't have evidence of it after. Ms. Bredehoff says nothing about IPV. And then, Your Honor, I highlighted page 246. This is where it starts. This is where Dennison says, I think the witness just said that she saw no prior evidence of IPV. And then he argues that that implicates the prior arrest of Ms. Heard because the person involved, etc. The court says, okay. Bredehoff said, and then he talked about the notes. And Your Honor may recall both Your Honor and I said, I don't recall her testifying to that. The court said, okay. Ms. Bredehoff said, and she didn't. And in fact, she mentions nothing of it in her disclosure, and she didn't testify to any of it. So Bredehoff is doing a good job arguing this does not open the door. We're keeping this evidence out. Bredehoff, or the court says, okay, Bredehoff said, so I think that's incorrect. I don't think she opened the door, and I don't think you can ask that question. So Bredehoff is doing a good job here shutting this down and saying the line that Dennison thought was crossed was not crossed. And here is all of it. The attorneys, when they go back at the end of the night, are not resting. That this is what they're doing. Mr. Dennison said, Your Honor, it is indirectly in her notes. Dennison, sir, it being in her notes doesn't open the door to it. But with respect to this testimony, there are symptoms that she has testified to relative to IPV, but she didn't say it. These are the emotional instability, dysregulation, fear of abandonment. These are all symptoms she was talking about ad nauseum with the assistance of her notes. That's exactly what we're talking about. That is a reach for Dennison. He's trying, but it's not going to fly. The court said, I think I'm just going to stay with what I said yesterday. You can ask the initial question about whether or not. Dennison said, I wrote down the question. And then they get into whether or not. And then Mr. Chu says, we've got it verbatim, the question that Your Honor allowed. The court, she wants to make sure everybody's on the same page. What is the question? And then Dennison said, I have it in my notes. Ms. Bredehoff said, so I'm going to allow him to ask her that question. Then they're trying to figure out what page they're on of the transcript. And then Dennison starts talking about the notes. I just want to try to figure out what we're doing with the notes. Is this witness coming back up to our cross-examination? The court said, yeah, we can't have her have the notes. If you go back and watch me getting frustrated at this expert witness was just straight reading from her notes and then got real snappy about it and was like, I don't want it to be a memory test. Ma'am, it's the fuck a memory test. That's why expert witnesses charge a fuck ton of money. It's not easy to do. It is a fucking memory test. That's exactly what it is. Yes, George. You can come say hi. It's exactly a memory test. Being an expert witness is a choice. You do not accidentally end up an expert witness. You could accidentally end up an eyewitness, but you don't accidentally end up an expert witness. That's why you charge the big bucks, or should. Ms. Bredehoff. The court says, yeah, we can't have her notes. We understand that, right? The court's like, we understand evidence, don't we? Everybody? Team. We're on the same page with this, right? The court says, she can't refer to her notes unless she asked to do it. It appears yesterday, even when I was watching her, she was still using her notes. This is how it goes if you are an expert and you need to refresh your recollection. You will look for this in every trial you see. Hi, George. If you're gonna, you don't get to sit on the lap until you say hi to the law nerds. You have to say hi first. You're breaking the rules. You don't get the cuddles unless you give the FaceTime. Yep. He's like, no, that's not a deal. That's not a deal. No deal. No deal. You can stay here. George scared the shit out of himself by knocking stuff over. Because cat. Are we surprised? Are we surprised? Oh, Georgie. Streaming with cats is hazardous. All right. So many streamers do it. It's always a hazard. Code George. All right. So experts, when they want to refresh their recollection, Dennison could ask, and this is just a pure hypothetical. Let's not use Dennison. That makes it too real to this case. Someone could ask an expert, what test did you conduct? I conducted the MMPI, whatever. And then the expert could say, on what day did you do that? And the expert could say, it was in June, but to know the exact day or to tell you the exact day, I would need to refresh my recollection. And then the attorney would say, would that be something that's in your notes, or would referring to your notes refresh your recollection? And they would either say yes or no, it's in their notes. And then they would say to the court, may the expert refresh their recollection? And the court would say they may, and then they can review their notes, put it down and say, my recollection is refreshed. It was June 16th, whatever. There is a process for this that is very common, very regular, and I did so often that I still remember it because this is a regular pattern of being in court with expert witnesses. Would it refresh your recollection? Is that in your report? Is that in your notes? Is that whatever? Yes, it might feel like kabuki theater. Yes, it might feel like a complete pantomime. However, it lets the jury know where the information is coming from. It lets the jury know that this is not something they remember. This is something that they had written down and they needed to look at it. That's all. And then the jury can assess whether that expert has a great recollection, if they're being shady, if they just don't remember dates well, if they testified well to other things, if it matters at all. Then the jury gets to decide because the jury weighs the credibility of witnesses. That's their job. So that is why this is the fuck a big deal. This isn't a big deal at a deposition. This is a big deal at trial. And also this is strategy because Team Depp can make their expert look incompetent. And that's what they want to do. Team Heard wants to make Depp's witnesses look incompetent. And that's why on and on and on about the muffins and the Moscow Mule and the rest, they want to discredit each other's witnesses. It's literally their job. So this is Dennison taking a swing at it. Ms. Bredehoff, Your Honor, I've always had experts bring their notes up there. The court, again, Elaine does not appreciate, or Elaine is pretending not to appreciate the distinction in bringing notes up and reading from them. The court bringing them up is one thing, putting them to the side and have them face down, which most experts do. Bredehoff, we'll tell her to make sure she puts them face down, and if she needs to refer to them, the court, no. I can hear Judge A just being like, no, ma'am. Ma'am, we tried that yesterday. That didn't work. Yeah, for all of you that are fans of Chicago, it's not that far off. You know, we're giving them the razzle dazzle. Caroline Spelt, this is what I think reading all of these sidebars, all of them. Why isn't anybody ready? Yep, this is the court all day long. All day long. We try to make transcripts interesting. The part of trial we don't get to see. The court, no. Ms. Bredehoff, what should she do? Elaine, you're the lawyer. Tell your expert what to do. The court, Elaine, what should she do? It's like when your kid looks at you at 15 years old and is like, how do you want me to unload the dishwasher? With your hands, sir. Preferably a towel. I would like you to dry the things that are still wet and put them where they go, the same way you've been doing it for years. Don't be coy with me. What should she do? Stop it. The court, I don't think she should bring them to the witness stand at all. That way, maybe she won't have the urge to read her notes. The urge, I think maybe that'll be better. And if she thinks she needs to refresh her recollection, she can ask Mr. Dennison, and then maybe her notes can be retrieved for that one question. Is that okay? Mr. Dennison, I have a significant number of questions for her. Oh, yes, I bet you do. But I don't think it's going to be anything close to a memory test. The court, okay, so just don't have them. Ms. Bredehoft, may I tell her that? The court, you have a few things you have to tell some different people, Ms. Bredehoft. Do your job, Elaine. Go do your job. Go tell them. Go tell the PR dude that he can't be on his phone. Go tell Eve Barlow that she's yeeted from the courtroom and she needs to leave. Go tell your expert that this is the fuck a memory test. Go tell them, Elaine. I'm sorry I'm giving you homework, but I need to get that done. It's totally upsetting. Ms. Bredehoft, I totally agree. I feel exactly that way, Your Honor. I feel exactly the way Your Honor does. I totally respect Your Honor. Okay. Elaine, I'm sorry, Your Honor, I'm sorry. She's trying, Your Honor. Bless her heart. The court, all right. Ms. Bredehoft, there's one more thing as long as we're up here, ma'am. Read the room. Now is not the time. There's one more thing. We think there's going to be, Ms. Hurd is going to be on after Don Hughes. The court, which is after lunchtime. Ms. Bredehoft, we anticipate there's going to be some significant hearsay exceptions. Oh. At the beginning of the day, before they called Amber Heard to testify, Elaine said to the court, we expect there are going to be significant hearsay objections. The foreshadowing is delightful. So Elaine was exactly aware of what was going to happen. Elaine knew exactly what was coming from Camille Vasquez. That's fascinating to unearth. That's fascinating. We anticipate there's going to be significant hearsay exceptions to that because they've been accusing her of falsifying prior testimony. So we've prepared a brief, and I just wanted to give it to Your Honor. They prepared a written brief. The court, okay, so we can start dealing with the issues. Ms. Bredehoft, right. We think there are some cases that are pretty on point to this. The court will take a look at it. I'll take a look at it. Ms. Bredehoft, thank you, Your Honor. Mr. Chief, thank you, Your Honor. Mr. Dennison, thank you, Your Honor. The court, okay. Open court. All right. Are we ready for the jury then? I don't know how much time they gave Elaine to go talk to all the people. Dennison, yes, Your Honor. The court, wait, no, not yet. I put my microphone on. Sorry, Judy. Are we ready for the jury? Yes, Your Honor. The court, yes. And then the jury enters and they get into the cross-examination of Dr. Dawn Hughes. We're going to go to the next sidebar. If on my new keyboard, I can figure out how to control F ourselves to it. Where? That's not it. That's not it. That's not it. Where? Why? Nope. Did it work yesterday? Yes. Is it working now? Totally isn't. Why not? Where? Huh. That's annoying. All right. I guess we're not going to get to control F ourselves. I was so excited. All right. We're going to just go page by page for sidebar like we did during members only. Actually, let me see if I can refresh this and see if it'll work. Because A, I don't want to be scrolling forever. And B, I made it work yesterday and now I'm pissed that it's not working. Let's see if we can do that without. Sorry, y'all. You taught me how to control F myself and I'm still only good at it sometimes. We can do it this way. Yay. All right, I figured it out. I tried to control F. I tried to command F. I tried all the Fs. None of the Fs worked. All of the Fs were F'd out. All right, let's see. First sidebar, second sidebar. All right, sidebar number 2. Dennison, Your Honor, can we approach? Yes, sir. Dennison, thanks. During the testimony of Don Hughes, 1246, which opposing counsel insisted come in as a full exhibit. The court, all right. When we get to the last page, there's a legal history that addresses her arrest for domestic violence. This is Dennison talking about Heard's arrest for domestic violence after apparently Elaine had entered it as a full exhibit. The court, okay, Ms. Bredehoft, Your Honor, I would want this redacted. I wasn't aware, but I don't have the exhibit. It seems like it's their exhibit. It's Elaine's exhibit. Elaine should have had the court redact it before. But again, this is Dennison being an officer of the court, not being shady. The court has already ruled the door's not open. The court has already said we can't do this. Dennison sees it and approaches to the court and says, hey, by the way, heads up, this is in here. It's already been admitted as a full exhibit. I wasn't aware, but I didn't have the exhibit. It's your exhibit. Okay. Dennison, I would like to ask Ms. Bredehoff. It also has the dogs. It has all of that on the page. I would want that redacted. Dennison, these are the notes that this witness took with respect to her initial intake relative to the domestic violence. And Tasha is an intimate partner who was identified in the intake form. Tasha being Amber Heard's ex-girlfriend. Ms. Bredehoff, Your Honor can see this is legal history. The court, I'm sorry, wait, where am I looking? It sounds like these attorneys are talking quickly. Ms. Bredehoff, legal history, it doesn't say intimate partner violence. It also says, Dennison, the arrest is for domestic violence. Ms. Bredehoff, the arrest, that should stay out. That should have been redacted, Your Honor, or that should be redacted. Elaine! I know they were dealing with a lot of exhibits. But this seems like a big one because they were fighting so hard to keep it out. And it would have stayed out if they hadn't opened the door for it, and they did. It would not have come in. And in fact, even at the end, the fact that Amber Heard was arrested for it did not come in. It was just the actions that came in. So, the court then says, so what are you asking me? There we go. I saw the motion to embiggen the exhibit. The arrest is for domestic violence. Ms. Bredehoff, the arrest, that should stay out and that should be redacted, Your Honor. The court, so what are you asking me? Are you asking me if you can ask her about it because it's in her notes? Dennison, I'm asking to ask her being Dawn Hughes. I'm asking to ask her about because Ms. Heard identified this as part of her legal history, and this incident included an arrest for domestic violence relative to an intimate partner. The court said, right, but she didn't testify to it. Ms. Bredehoff says, no, they're talking about Dawn Hughes. The court, I have the motion in limine in place, so I'm just not going to allow it at this time. Dennison is trying every which way to get this into court, and it is not happening. Bredehoff, I asked that this page be redacted. I asked before that we go through for redaction. This is one I'm asking for redaction. Dennison, so the motion in limine allowed me to ask that single question. The court said, no, I believe that the door ain't opened. Okay, Judge A. If she testified to that, you definitely would have been able to get into it, but in the motion in limine, you wouldn't be able to get into it unless the door was open. But I just want you to know, if the door opens, the door opens. This is her talking to Ms. Bredehoff. If it gets into intimate partner violence and the fact that Amber Heard is saying that she's never been in a relationship like that before, the fact that she was arrested for domestic violence and the facts of that arrest can become relevant at that time. It goes on to say, but I think the last page has to be redacted. I'm waiting for redactions anyway. You have a chance to look at it. Bredehoff said, okay. The court said, all right. Dennison said, thank you. The court said, all right. And then they go back to open court and talk about the temporary restraining order. Next sidebar. This is them still talking about exhibits. And this is still on the examination of Dawn Hughes, the cross-examination of Dawn Hughes. Your Honor, I move for the admission of defendant's exhibit 1859, Dennison objection hearsay. The court, all right. Oh, so this is on redirect. Ms. Bredehoff, I would argue the completeness for that. The court, you can approach for this. The court. I just want to make sure they just did the first page. Is that the actual test or is it the Bredehoff? It's the entire test. The court, you want the entire test. I understand that, but the first page was just a summary of it. Ms. Bredehoff said, no, the 2 pages that he put in were a page from it, and it wasn't even the beginning or a summary. It was a particular snapshot. It's 1 page from a particular area. Dennison said, I asked the witness about the critical items identified on the test. I didn't go into anything other than the critical items on the test. That's why I put those pages in. The court said, okay. So they're arguing completeness. Like, hey, you can't just pick and choose. A document is a document. You need the whole thing. You can't just say, this little bit says that. You need the context. So that's what they're trying to argue, is that you need the whole context for it. The court said, all right, I understand the objection by him. I'm going to sustain the objection because there are things in there that the court is saying is not evidence and they don't need to be complete. Thank you, though. I just want to make sure, Ms. Bredehoff. Okay, thank you. Back to questioning the witness. Bredehoff questioning Don Hughes. So this is on redirect. Zoom out and go to the next sidebar. All right. Court overruled. They're playing audio. This is audio of Mr. Depp saying, I left last night. Honestly, I swear to you, because I just couldn't take the idea of more physicality, more physical abuse on each other, because had we continued, it would have misheard. I know. Depp gotten fucking, bad. Baby, I told you this once. I'm scared to death of this. We are a fucking crime scene waiting to happen. Heard, I know. Depp, if we don't get our shit together, and by getting our shit together, that might mean fucking we do this, we make it. That might mean damn, say I tried, done, toodaloo. So breaking up. So they're going through that audio. Ms. Bredehoff, do you recall listening to a part of that tape? Yes, I do. This is Don Hughes. And then what do you recall from that portion? Again, I know it's hard to hear. It's hard to hear, but what I recall from hearing that was the negotiation that the couple is trying to do and trying to say, I'm going to do my part. I'm going to do better. Okay, Bredehoff said, is it possible to turn it up anymore? My last one is at this timestamp. Dennison said, Your Honor, can we approach? So that's the context they're approaching in. Dennison, all of this is beyond the scope of cross. So when you do redirect, cross-examination can be on anything that's proper evidence. Once you get to redirect, it has to address the things that are said in cross-examination. So if you don't ask a question about it in cross-examination, you can't bring it up in redirect. You needed to do it in your direct argument. So if Dennison had gotten up and asked Don Hughes one question, hey, Dr. Hughes, is the sky blue? And sat down, then the only thing that could be asked on redirect would be, how do we determine color anyway, right? It would be talking about the sky is blue. You can't go outside the scope of that. You have to do it in your direct examination. This can also be a trial strategy. If they forgot something big, don't ask about it on cross and they can't get into it. That doesn't happen as much in criminal court. There tends to be a little bit more leniency in this. But in civil court, there's not a lot of leniency, and they were on a really tight time schedule. The court said, well, you put the audio tape in. So Dennison introduced the audio tape, and the court's like, it's in evidence. What is your problem here, my guy? The court, well, you put the audio tape in. Dennison said, every audio tape comes in because I asked about one thing. Bredehoff said, it's the same audio tape. And the court said, it's the same audio tape. This is the last, correct? Bredehoff, yes. Dennison, thanks. And the court was like, no, sir. No, sir. You can ask about it again. Nope, we're not doing that. We're not playing these games. You can talk about it on your recross. If you want to burn your time that way, burn it. Let's go down to the next sidebar. Let's see what the context of this one is. They are arguing something. Oh, the knife. Who are we talking about the knife with? Let's see. Bredehoff, Dennison, this should still be Dr. Hughes. This is about Bonnie Jacobs. There's a bunch of objections. Let's see. You were asked about a knife. You were shown Plaintiff's Exhibit 92, a knife that's, I think, until death. What is your understanding of the significance of that knife? Dennison, objection, Your Honor, no foundation. Bredehoff, he showed it in cross-examination. That doesn't mean there's a foundation for your question. I'm able to ask about what her understanding is. He cut her off when she was trying to talk. I'm just letting her go back in. Dennison, her understanding of a knife? Ms. Bredehoff, let's pull up Plaintiff's 92. Tom, could you do that? This is why we approach. The question was asked by counsel for Mr. Depp. You said it depends on the context. What do you mean by that? Well, first, I believe that this is the knife that has a turquoise end. This was when a time when Mr. Depp was filming The Lone Ranger and he was in a turquoise phase, and she purchased him that because she felt it would be a kind gift. The phraseology is that Mr. Depp told her the only way out of the relationship is death. Okay, Dennison said objection hearsay. Bredehoff said, I don't understand the objection. She's entitled, and then says, I think she's entitled to speak to that. Court said, but Ms. Bredehoff said, yeah, it's Mr. Depp's statement, a party opponent admission. The court said, I'll overrule the objection. I don't agree with the court on that one because it's not. How much into hearsay do you go into at the moment? I'm going to try to do it short. I'm going to try to keep it brief. Here's the thing. We've got buried hearsay. So we've got a statement from Depp. Team Heard is allowed to elicit statements from Depp because it's the admission of a party opponent. Depp is the opponent. But what they are eliciting from Dr. Hughes is a statement from Amber Heard stating what Depp said. So you have multiple layers of hearsay. If Depp had told the doctor that would be one thing. But Depp allegedly told Heard, and Heard allegedly told Dr. Hughes, and Dr. Hughes is now telling the jury. It's too many layers of hearsay. This is like following a story when your kid comes home in junior high and is like, and then so-and-so told so-and-so this, and then so-and-so did this. And you're like, what is even happening right now? I cannot follow. You can't evaluate the statement when you've got multiple layers of hearsay. And then it becomes a mess. So I don't agree with the court's ruling on this, but I think at this point, the court is like, this shit is out of the horse. It's fine. Telling the jury to disregard is dumb. And Depp already talked about the knife a little bit. And then Amber Heard's going to talk about the knife. So I think the court is just like cutting the argument at this point. Ms. Bredehoff, thank you. What is your opinion? What do you think of that as a clinical psychologist specializing in IPV and trauma? And there's the problem. We have spent pages of them arguing over whether Dr. Hughes was going to give any opinion with regard to IPV. And the court said, no, ma'am, she's not giving an opinion on that. It wasn't in her designations. We're not doing this. And now on redirect, Elaine is trying to elicit it again. And Dennison's like, object, can we approach? Because they've been fighting over this at Sidebar for like a day and a half. Oh, I'm annoyed. Dennison, we're about to launch into yet another undisclosed opinion that's not reflected. Ms. Bredehoff, this is from cross-examination. What?
Your Honor, it's fine. He asked in cross about the knife, so it's all related, isn't it? I think she's entitled. Your Honor, I think she's entitled to get into that.
This is from cross-examination. The court said, I know, but it's still an opinion. Because she's eliciting an opinion. Ms. Bredehoff's question. What is your opinion? You're eliciting an opinion. Ms. Bredehoff, yeah, but if it comes up in the examination, I didn't raise that with her. This is something he raised. I can ask her about it. You can ask her, but you can't elicit an opinion. It's sneaky shit. The court, you did ask her about it, but I don't think her opinion on it is a different matter. These are significant differences. This is not splitting hairs. These are substantial differences. No wonder everyone was put out with each other by the end of the day, right? Ms. Bredehoff, I'll try to rephrase it, Your Honor. Okay, thank you. Yeah, you can't elicit an opinion. The court, okay, thank you. Ms. Bredehoff, thank you. Dennison, thank you. Back to court. Dr. Hughes, what do you think that the phraseology on the knife bears any relationship or significance to the opinions you've had in this case? I'll try to rephrase it. Instead of saying opinion first, I'm going to bury it later in the sentence. And if I bury opinion later in the sentence, then we're good. No, ma'am. No, ma'am. This judge is smarter than that. This attorney is smarter than that. What you're not going to do is you're not going to sneak this in. You're not going to sneak this right in. Mr. Dennison, objection. Sustain the objection. What, if any, significance does the phraseology of the knife have to the opinions you have provided in this case? Objection, Your Honor, beyond the scope of the disclosure. Ms. Bredoff, he brought it up on cross, Your Honor. You just fought about this at Sidebar. Now you're fighting about it again in open court. The court already told you. And so now the court has backed down. I'll overrule the objection. I imagine that at this point, Dawn Hughes doesn't even know what's being asked again. And then Dawn Hughes answers what she thinks there is. Then they go back to the audio tape, and then we have another sidebar. Is this witness subject to recall? It seems like this witness is done. Ma'am, you can't discuss your testimony with anyone. You're free to stay in the courtroom. Dennison, may we approach? Okay, Your Honor, I'd like to make an oral motion to strike those portions of Dr. Hughes' testimony that exceeded the scope of the disclosure. He's not letting it go, and he shouldn't. That's his job. And Elaine didn't let it go. And Elaine eventually won and got her way because she kept wearing the court down on the way she was phrasing it. And the court was like, just ask her. Just ask her. And now Dennison's like, I'd like to make an oral motion to strike the portions of Dr. Hughes' testimony that exceeded the scope of the disclosure, including all evidence related to the MMPI-2, her views on personality disorders, and her testimony relative to the various communications she had with other doctors as to personality disorders. None of that appeared in any of the 4 disclosures she made. The MMPI-2 information was Dr. Curry's disclosure, and she had every opportunity to rebut it. Ms. Bredoff, Your Honor, these need to be made simultaneously if he's going to. Mr. Dennison, I did object. Ms. Bredoff, I don't agree that you did simultaneously object. They're fighting over when he objected. He objected every single time she said the word opinion. And Elaine is showing you that she is not unaware because she knows exactly what she's arguing. I don't agree that you did simultaneously object. And they were in the disclosures, and they were in her deposition. I read through the deposition last night. The deposition and the disclosures are different. I read through the deposition last night, so I don't think there's any basis whatsoever for striking those. Your deposition and your disclosures are different, and if it was in the deposition and not in the disclosures, you should have caught it and had her do an additional disclosure. Maybe. Dennison, this is exactly the conversation we had yesterday when we asked opposing counsel, where in the disclosure does it say? The court, right, and I sustained the objection. Ms. Bredoff, exactly. Your Honor sustained the objection. Exactly, Elaine. Sustained it, not overruled it, and then you kept asking. Dennison, but it was much broader testimony. I made repeated objections. The court, I'm going to overrule the motion, okay? Bredoff, thank you. Dennison, thank you. At this point, Dennison has to have steam coming out of his ears. The court, we're going to take our lunch break. They took a lunch break. And then we came back calling Amber Heard to the stand at 12:49 p.m. Bredoff, I have one housekeeping matter, Your Honor. All right. There are 4 tape recordings played out of 343. And then they're talking about that. And then the jury comes back in. Your Honor, we would like to call Laura Amber Heard. Just in case you had forgotten that after all of that, Elaine calls Amber Heard to the stand by the wrong name. Just in case you forgot. Oh, Elaine. She's trying. I think they needed to divide up these witnesses differently. I don't think Elaine, if they knew they were going to do Dr. Hughes and Amber Heard back to back, Elaine should not have been dealing with both of these witnesses. The way that the law firms managed and did their witness management is so vastly different. And I am so curious as to why Team Heard chose the witness management that they chose. Because it doesn't seem like a strategy that leans into the best of Elaine's skills. And I think you could have had another attorney easily question Dr. Hughes. And I don't know why they didn't. I don't know why they chose to have Elaine do all the witnesses that she did. You can see how many different lawyers Team Depp divided things up amongst. You saw if you are running a law firm, look at the way they divided up their work and the way they scheduled out their witnesses. It was strategic. It was really well executed. You had Ben Chu kind of quarterbacking the whole thing and making the legal arguments and focusing on those and listening to what's happening in court and handing notes up to support the attorneys. So he's big picturing it. And then you have Dennison handling just the experts, which were divided up. So he has time to refresh and reset. But when the other witnesses are going, Dennison doesn't really need to pay much attention to what Amber Heard is saying on the stand because nothing's going to be really new. All of it's going to be in depositions and stuff you've already heard. So he then gets to focus back on what just happened and emotions that need to happen and get ready for the next expert that's going to come up in a day or two. It gave everybody time to refresh and to focus. And I think any of the lawyers on Team Heard would have done fine with Dr. Hughes. Unless like Rottenborn was just like, I'm not, no. Miss, this isn't a memory test. Like, no. Could you imagine? The Rottenborn would just be like, I'm not talking to that woman. It's possible. All right. Where are we at? I think 10K is our next goal, right? For likes, for more memberships. I think we're getting there. I mean, there's 17,000 of you here. Hi, everybody. I know I'm not playing video games. We still have almost 20,000 people in the chat. Because we're all fascinated. So welcome, new law nerds. You can do the subscribing things too. Road to 1 million and all that. Whoop, whoop. Okay. Elaine. Your Honor, we would like to call Laura Amber Heard to the stand. If I am Amber Heard in this moment, I am fucking furious that I have sat through 15 days of trial, years of litigation, and my lawyer calls me the wrong fucking name. Pissed. I would be pissed. And testifying is real fucking stressful. Laura Amber Heard. Amber Laura. Amber Laura Heard. I died. I die again. All right. Will you please state your name? Yes, it's Amber Laura Heard. And with that was the beginning of Amber Heard's testimony, background, upbringing. I thought at this part of her testimony, she testified well and relatably. And then she started looking over to the jury quite a lot, and it got a bit exaggerated. All right, let's see what's happening here. Ms. Bredehoff, thank you. I don't know the question. Wait, no, that was the wrong sidebar. Where are we? That's Dennison's sidebar. All right. I'm trying to back up. Where's the objection? Defendant 1783. Do you recognize this picture? Yes, I do. This is the direct examination of, I almost said Laura, of Amber Heard by Elaine Bredehoff. Do you recognize this picture? Yes, I do. Could you tell us what it is? It's a picture of my face with a note that Johnny left for me by the coffee. Typically is where we'd leave notes like that. And does it accurately depict the scene portrayed? It was one of those scenes. As embarrassing as it sounds now, I don't know what scene this came from. There was a lot. It escalated quickly, fast, and it became, Amber, let me ask you a different way. Thank you. Is this a picture of you? Is it an accurate picture of you? Yes. Bredehoff, Your Honor, I'm going to move for the omission of 1783. Vasquez, Your Honor, we have an objection. May we approach? The court. Okay, sure. Vasquez, Your Honor, this is a photograph that was produced after the close of discovery. Remember how we talked about rules earlier? We talked about rules in discovery. This is one of those things that once discovery closes, it is closed. Like there's no like loosey-goosiness to this. And these rules are known from the beginning of trial. And sometimes these dates push. Normally, as trial gets pushed back, the discovery cutoffs push back. So it's not like the discovery cutoff ends arbitrarily and then the trial gets pushed and then those don't get pushed. Your Honor, this is a photograph that was produced after the close of discovery. The court, okay. We object on that basis. And yeah, Bretta Hoff. This is one of the pictures that Craig Young identified, gave it to both of us at the same time. There are a number of pictures that both sides got when he went through the different time periods, the court, right, and produced the pictures. And that's where it came from. We both got them at the same time. There's no prejudice. Actually, first of all, note for reading transcripts. When you see these little dashes, it means that people are talking over each other. So the court said right in between Elaine's sentence. Vasquez, the prejudice is, Your Honor, that these came from devices that were in Ms. Heard's possession, custody, and control. They represented to the court several times when you granted our motion to image Heard's devices that the devices had previously been imaged. Why this photograph and a number of others weren't produced is a problem before the close of discovery. So the argument is, Elaine said, well, we didn't get them till they got them. Well, you had the devices. And if you had the devices, you had them in your possession, even if you didn't know they were there. And if the devices were already imaged and these images weren't on it, where did the images come from? Were they edited images? Are they true images? Either way, the discovery cutoff is a discovery cutoff for a reason. You can't just, sneak-a-doodly in some other images. You can't whoopsie-doodle images. Well, discovery closed, here's all this. No. Trial by ambush is not allowed. So why this photograph and a number of others weren't produced is a problem before the close of discovery. Bretta Hoff, there were hundreds of thousands of pictures, Your Honor. Well, Your Honor, it's just a lot. I mean, we had years to go through it. No, Elaine. Your Honor, it's just a lot of shit. No, the court said, right, but if you wanted to use it at trial, it should have been provided in discovery. That's why we have discovery cutoff dates. Bretta Hoff, we didn't discover it until then. The court, tough shit. I mean, that's not what the court said. What the court said was then I'll sustain the objection. Sustain means granted. Bretta Hoff, okay, thank you. Ms. Bretta Hoff, will you please describe for the jury some of the cycles you had with Mr. Depp through 2012? And then they went back into something else. To Bretta Hoff's credit, she did a very good job of just moving on and getting to the next thing. Did you tell anyone? Yes, I did. Who did you tell? I told my therapist. I told my mom. Let's go ahead and look at Defendant's Exhibit 150. Your Honor, I'm going to object to hearsay. All right. Do you want to approach Vasquez? Yes. The court, Michelle, I'm sorry. Could you make it a little bigger just so I could see it? I'm sorry. I apologize. All right. Thank you. So that's the court talking to her court assistant. Bretta Hoff, Your Honor, this is the reason that we submitted a brief this morning. Because we think there are a number of hearsay exceptions for these communications. Oh, so Elaine is aware of the hearsay exceptions and briefed them before Amber Heard got on the stand. Who would have known from watching this trial that happened? I wouldn't have known because it looked like Elaine was perpetually caught off guard. Maybe that was her shtick before the jury, but it looked like she was perpetually caught off guard. She's not caught off guard by this. She filed a motion that morning. Very well aware. Maybe she wanted the jury to think that she was being beat up on by Mr. Depp's big fancy lawyers with their big fancy tests and their big fancy experts and ho hum, we're just trying to do this or do that. Your Honor, this is the reason we submitted a brief this morning because we think there are a number of hearsay exceptions for those communications. One of the most significant ones, the court said, hold on, wait till she comes back. Ms. Bretta Hoff, that's fair. It seems like Vasquez probably went and got something and came back. Okay, we'll go through it line by line. Which one do you think? Okay, so who is this text between? Let's get that straight. Bretta Hoff, this is a text between she and her mother. Her mother's now deceased. The court, okay, so she and her mother. Okay, Bretta Hoff said, I think the most significant one that we want to get is the blue one. The court, the blue was Amber. Quote, I don't know what to do. He's texting saying he wants to talk today. I haven't answered the text back. Okay, so what issue? That's clearly hearsay. What's your exception to hearsay? Agreed. That's clearly hearsay. Ms. Bredehoff, exception is present sense impression. Ma'am. No, it's, am I going to have to go get my hearsay, my rule of evidence book? Where is my evidence code? I might have to grab it. That is not a present sense impression. It's not describing something. If your friend calls you and is like, God, this is going to be this already started as a dark example. I apologize. If somebody calls you and is like, I think somebody is breaking into my house, you're going to tell them to hang up and call 911. But if they've already done that and they say, I hear glass breaking, it sounds like it's downstairs, it sounds like this, and then I hear a voice, and then you hear over the phone the voice, and then you hear them saying, get the fuck out of my house, or whatever it is, that is them relaying a present sense impression to you. If you are talking on the phone with your friend and they are driving to work saying, oh my God, there's a car swerving in front of me. Oh my God, it just hit this, this other thing. Oh my God, I'm stopping as quick as I can. I think the car behind me is going to, that is a present sense impression of the shit that is happening in the moment. Texting your mom to say, I don't know what to do, is not a present sense impression. So that is not the right exception. Exception is present sense impression, no. Because under the rules, and that's why we filed the bulletin on that, the court said, go ahead, because it's stating what's going on, what she's expecting at the time. No, it's not. She's not retelling on the phone with her mother, he just came into the house, I think that he's drunk, I'm scared, blah, 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 blah. No. He asked to talk. Okay. Ms. Bredehoff, because it's stating what's going on, what she's expecting at the time. No, it's not. We also think it's sort of a state of mind and present physical condition. It's not a state of mind. Okay. The court, okay, Bredehoff. And then the other thing that I wanted to bring to your Honor's attention is that we believe that these are prior consistent statements. Ma'am, no, you've gone too far, Elaine. The court, well, she hasn't been impeached yet, so you can't do prior consistent statement. That's an easy one. Damn.
The court's just being cold as fuck with that. Ma'am? Negative. And that's an easy one. Like,
the court's just sitting there being like, you have reached too far, Elaine, because we're not even there yet. We can't even cross that bridge. We haven't even come to it. Ms. Bredehoff, I understand. The court said that's only on redirect. You can do that on redirect if she's impeached. Ms. Bredehoff, I understand your Honor's ruling on that. And I think that they have already done so during their opening statement. It's not how any of this works. Law students, any of you that are law students, if you want a refresher on the rules of evidence, I would use some of these sidebars as the hypotheticals that are more interesting than whatever your teacher is going to come up with, because these are real life hypotheticals where you are going to get to sit here and go, this is why this isn't a present sense impression. This is why this isn't a prior consistent statement. Use the transcripts to easy spot, to essay spot, or just the issue spot, sticks and yarn. I saw your comment in the chat and went, where did it go? Sticks and yarn in the chat said, where did it go? Chat, y'all are going fast today. It's okay. I normally see it better, but it was hilarious about this. That's an easy one. And the fact that the judge was just like, no. They did it during their opening. No, that's not how that works. You can't impeach someone during your opening. The court doesn't even respond. The court just says, no. Me, Ms. Bredehoff. But taking that one aside, in the cases, Your Honor, in present sense impression, so now Elaine's going back to the other ones to try to end route the thing. She's trying to just sneak it in through the side door. This is something that she's stating at the time. And the court said, right, I've read your brief. I understand that. But the thing with present sense impression is it's present sense impression, not past sense impression. The court is now getting snarky with the rules of evidence, and I fucking love it. So present sense impression has to be something that she's involved with at the time. Can't be a past, quote, he called me, he texted me, he wants to talk today. I haven't answered back. That's not a present sense impression. So the court has now lost her patience. It's just like, no. Ms. Bredehoff is like, and the last one is state of mind and present physical conditions. Ma'am, no. And that's for the current state of mind, emotions, sensations, or physical conditions. I think she's reading from her brief or the rule of evidence. Or physical condition such as enhanced motor design, mental feeling, pain, or bodily harm. Yes, somebody yelling, I think my leg is broken, is a statement of a present physical condition. All my examples for state of mind come from the criminal context and all of them are dark. So I'm just going to skip over and see what the court has to say. The court said, go ahead. I know it was a new state of mind. Ms. Vasquez, Your Honor, it's not a state of mind. This is a text, like state of mind could be, if somebody gets in the car and says where they're going. Again, most of my context for this are criminal cases. Says where they're going and then doesn't come back. And never comes back. The person who they told that could say, when we last talked, they said I was going to so-and-so's house. Like, Taylor Shabusiness's victim's mother could say, he said to me, I was getting together with Taylor Shabusiness for the evening. That was his state of mind. That's what he thought he was doing. Some of that is not going to be hearsay. So, not always great examples, but that it's your state of mind, what you intend to do, where you're going, whatever. Your Honor, it's not a state of mind. This is a text saying we don't know when she said that in relation to whatever. The court said what she's talking about. That's not a proper way to bring in hearsay. The court said, okay, all right, I'll sustain the objection. Thank you, Your Honor. I will be continuing to try with some of the others. Bless your heart, Elaine. Your Honor, I will be continuing to try with some of the others. Elaine knows this is going to be a shit show and just tells the court, Your Honor, welcome to the fucking circus. We're going to just keep doing this. The court, you can keep continuing, but present sense impression is present sense impression. So Ms. Bredehoff says, she's saying, I don't know what to do. The court, that's hearsay, clearly hearsay. Okay. I'll sustain the objection. Woo. Back in open court. So why did you decide to confide in your mother about the issues you were having with Mr. Depp? Elaine just kind of wove it in to her question, right? She wove in the impression that they were having problems into her question to kind of move it back along. She recovered the questions well there. Let's see. We need to back up. When did you start confiding in your mother about the abuse you were suffering at the hands of Mr. Depp? And then Amber Heard starts to answer. I was confiding in her from the very beginning about the abuse, the psychological abuse, the kind of control, the disappearing, the not knowing where he was. Then he'd come back, and sometimes in the middle of the night, and the consistent accusations. I would talk to her about that, and she'd keep going. And it was all just very isolating, and I confided with her at the very beginning on that sort of thing, and then later opened up to her about some of the violence. I did it gently, First, I just wanted to have someone to talk to about how scary it was. The rage, the uncontrolled violence, the rage that this man had, and why it just, objection, Your Honor, may we approach? Okay. Your Honor, she's characterizing hearsay. And she said she confided in her mother, but she's starting to characterize what she said. Amber Heard can testify how she felt, what she saw, what she did. But she can't testify, I told someone this. She can just say, this happened. And they keep flipping it. I think it's just as powerful to say, this happened. I was struggling with this. I talked to my mother about it. That's it. I talked to my therapist about it. That's it. You can't say what you said. You can say what happened and then say, I talked to people about what happened. But you can't testify, I told them ABCD. And they are flipping it. And I don't know why. Just testify about what happened. What you saw, what you heard, what you did. Not what you said. Ms. Bredehoff, the court says she said she confided in her mother, but she is starting to characterize what she said. She's saying it without saying I said. Ms. Bredehoff, I don't think she was characterizing. I think she was saying what she felt. I didn't hear the court. She was kind of saying what she was saying. I'll sustain the objection. If you're close, we can have our break whenever you feel like you're at a good breaking point. I think Elaine is definitely at her breaking point at this point. Elaine, this is a good time. Okay, thank you. Thank you, Your Honor. Ladies and gentlemen, we have a break. The court, all right. Ms. Hurd, just remember you're on the stand. Thank you. Recess, back from recess. The jury entered. Here, back into the testimony. Let's back up. Ms. Bredehoff, and if we could scroll up, is this a text message exchange with your mom? I have a hair on my lip. Me. Is this a text message exchange with your mom? Correct? Yes, it is. Let's scroll down. I mean, Your Honor, I'm going to object to hearsay. Ms. Bredehoff, let's wait until we get to the spot. Elaine's like, can we wait? Can we not do that now? Let's wait till we get to the spot. All right. And this picture you sent to your mom on 3/23/13? Yes, it is. Ms. Bredehoff, Your Honor, I'm going to move for the admission of 170. Just that picture that's on the text, the court with no words. Ms. Bredehoff, well, it says from 2 weeks ago on it. Ms. Vasquez, Your Honor. Ms. Bredehoff, if we redact the from 2 weeks ago, this is all said in front of the court, in front of the jury, right? If we redact the from 2 weeks ago, can we admit it then and just have the showing that she said it to her mom? Your Honor, can we just? Ms. Vasquez, may we approach? Your Honor, okay, sure. Ms. Vasquez, this is highly prejudicial. She just read into evidence hearsay. I think she means she just read into evidence. Oh, she just read into evidence hearsay. Because she just said it all in the record. This is from 2 weeks ago, blah, 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 blah. Elaine just like said it all in open court in front of the jury. Shit horse, right? They've heard it. They can't unhear it unless they're not paying attention, but they've heard it. The court will sustain the objection. Ms. Vasquez, I know. Sassy. Ms. Vasquez getting annoyed before cross-examination even starts. The jury's been instructed about if I sustain, they'll be instructed on it again. Ms. Vasquez, thank you, Your Honor. Ms. Bredehoff, so I just want to have the top show that she sent it to her mom and the date, and then we can redact the from 2 weeks ago. It just shows that she sent the picture because Your Honor's already ruled that that's not coming in. Any objection? No. So everything else is redacted on the page except the picture and the date. Is that what you're saying? The date underneath? Ms. Bredehoff, we would have to show that she sent it to her mom. Okay, everything else redacted? Okay, great. Redacted. Let's go back to the next sidebar. This is all getting into, what she told her mom or didn't tell her mom. All right, I guess that's just not gonna zoom out for me. Let's see. Back to photos. The court, this might be your number 167A, but it's in evidence as plaintiff's number. I'm not sure which plaintiff's number it is. I don't need it in twice. Ms. Bredehoff, I would agree. Do we, Ms. Vasquez, Your Honor? I don't think that this version, two can play at that game, Elaine, and Camille's playing it now too. Notice how what Camille says is, I don't think this version of the photograph has been admitted, implying that there are two different versions of this photo, which we know they get into in rebuttal. The court, it's a different version, same photograph, but a little different. Is that what we're, Ms. Vasquez? It's not the same photograph. Okay, not the same photograph. Then we'll go with what number is it? Do you recognize this photo? Yes, I do. So now they're numbering it. Please tell the jury what it is. It's a picture I took of my breakfast table that morning. Oh, this is the table with the cocaine and or purported cocaine, because nobody tested it. So I guess purported cocaine and driver's license and tampon plastic tube thing and whatever. Applicator. That's the word. Professional words. Your Honor, I'm going to move for admission. Any objection? Yes, Your Honor. May we approach? Sure. Ms. Vasquez, this picture appears cropped to me. So is that the full size or is it cropped? Or is it just showing this? I think this photograph is many different. The court, I'm sure there's different forms of it, but she's saying it's an accurate picture, even if it's cropped. That just goes to the weight of it. It's fine. Vasquez, okay. Any objection? Then no. So when maybe publish it? Yes. So then they're just like, okay, well, you'll have to question on it if it's cropped or not. Next sidebar. Hicksville. We're now at Hicksville. Did there come a time that you wrote an email, Ms. Vasquez, objection, leading, and hearsay, Your Honor, may we approach? All right. Regarding Hicksville. Ms. Vasquez, I'm trying to do this preemptively. Well, right, before Elaine just puts it all on the record. The court, all right, that's fine. Just so we don't have any more slip-ups. The sass. But this is an email that Ms. Heard claims she sent to herself. The court, okay. Ms. Vasquez, hearsay. The court, okay. Ms. Vasquez, there's no exception that applies. The court, hearsay. So what's the exception that you offer? She's, I'm sure, looking to Ms. Bredehoff. This one is definitely present sense impression and mental state, Your Honor. She's saying how she feels about all of this. Your Honor, I told you we were going to keep doing it. Your Honor, I told you we were going to come back. This one's the one, Your Honor. This one's the winner. Your Honor. This one, Your Honor. This one. Present sense impression. Let's go, baby. This one is definitely present sense impression and mental state. The court, okay, it didn't happen in May. This is from June 11th that she's sending it. It can't be present sense impression. She's not in the present sense. Ms. Bredehoff, she's not talking about this Hicksville now. This is a juncture in her relationship, and she's writing the letter to him, but sending it to herself, saying how she feels. The court, it's hearsay, sustained. I have more questions about it. I have more questions about this email. Ms. Vasquez, thank you. Ms. Bredehoff, in June, how are you feeling? So now Elaine has to keep recovering from this. She keeps trying. She keeps recovering. Her client can't say she didn't try. And we don't know if this is Elaine telling her client, hey, this is not going to come in, just so you know. And her client going, well, I want it to come in. And Elaine being like, not going to happen. And so Elaine's like, okay, fine. We'll throw it against the wall. But at some point you have a duty to the court to not extend this beyond what is permissible boundaries of evidence. That is the end of sidebars for day 15. Let's go to the end of the day and see how the day ends. And then we'll go to the next day. We've got time, right? Where are we at? We've got time. We've got time. Let's see. The court, if you think it's a good point, we'll break for the day. Ladies and gentlemen, we'll go. The court, again, ma'am, since you're on the stand, you can't discuss your testimony with anybody. And then that literally ends the day. Recessed till 10 a.m. The court is like, literally get the fuck out. Literally get the fuck out. Shall we go to day 16? Chat, shall we go to day 16? Let's take a minute and do a few super chats and we'll go to day 16. And we'll do the same thing. Let's go to the member chats and super chats. Let's see. Are you and the family still into trading card games? Yes, we are. Back from vacay, missed my Law 2 peeps. Welcome back from vacation, Diana. Good day, Emily. Can't wait for the sidebars. I hope you guys are enjoying them. Over 18,000 of you here in the chat. I will just say we are on the road to 1 million. Look, we are on the road to 1 million. There are very few lawyers on the platform over 1 million. I would like to be one of them. Thank you. Also, my 11-year-old says that I'm not a real YouTuber till I have 1 million subscribers. So it's become like a point of pride. Kelly said, thank you for the sidebars. This is where the tea, aka Cheesemay, is at. This is exactly where the Cheesemay is at. We get to see a different side of Elaine, right? We get to see that she knew this was all coming. We get to see that she had planned for it. It still didn't work out. We get to see all of this fighting happening, and we get to see the patience and sometimes the snark of Judge A. We get to see all of it. Octo, good to see you. I know. Of course, we're on a plane tomorrow. We'll see what happens tomorrow. Do not work with Netflix on any documentary. Ask Mandy Matney why. I did not work with Netflix on any documentary. Sometimes it's hard because I will get calls about documentaries, and the production company doesn't always know where they're selling it to. So they don't always say if it's going to Hulu or if it's going to Netflix. I tend to work where I have more information. So when I've done stuff for Hulu, I know. When I do stuff with ABC, I know where it's going. So I really do try to have a sense of where stuff's going when I work with them. Jamie Lynn said, hey, DB, I've been dealing with a legal BS from ex-husband. You have helped me be better prepared and not get screwed over by him. So thank you, Jamie. You are welcome. It can be hard. Remember, with legal emotions have to be processed and then logic gets processed. So emotions first, then logic. But let the emotions process. It's needed. You let yourself feel. I've been dealing with some stuff with work that has been frustrating me. And I'm like, I need to write an email. And I literally told my team, I'm like, I need a day or two. I'm too fucking mad. Like, I'm too mad to write this email. I need to be less mad before I can approach this logically. Knowing that is super helpful. And it's okay to be mad. And it's okay to vent that you're mad. Don't vent it in the email that you're sending to the other person. Hold that back. I know. Fall drinks, then Christmas drinks. Chat, are you saying that we've hit 10K likes? Chat, did we do that? Is it time? Is it time to drop more memberships? It is. Chat, you did that. It's time. All right. Make sure you have your gifting turned on. Y'all, make sure you do. We are dropping some memberships because we hit 10K likes on this live stream. Pumpkin cold brew at the grocery store instead of Starbucks has saved me so much money. This is a good tip. I will try. Behavior plan Pam is like here for all of it. EDB got the salted watermelon whiskey this weekend. Tried it with sister and brother-in-law. Dangerous. Played Hunt a Killer. Highly recommend. Hunt a Killer is a lot of fun. I hope it was amazing. The salty watermelon whiskey and the root beer whiskey are so good. They're so good. White mocha from Minnesota. Saw the last sidebar vid, but not the whole trial. Was there any point where it seemed like Elaine knew what was happening? There were definitely parts where she was sly like a fox. Can we add members only to text alerts? Soon, but not yet. Soon we can, but not yet. When we roll out a new messaging alert system, we can, but I can add the members only, the notice that it's happening to the emails, but not the link. And then the link will be in your member spaces, but I can add reminders into our text crew or into our emails. For you and Ian and Rob and all the ADHD, thank you. Greetings. Hello in Germany. Love all the tea. Oh, we're here for all of the inside scoop. EDB went to a Hailstrom concert this weekend, got objection out to reapply, and all of the women around me lost their minds. What is that? Where do you get it? And flashlight, lighters all up, held up the applicator. I mean, look, when you need a light, this is fantastic. And if you are in a dark room, a darkened restaurant, a karaoke bar, a concert, whatever, it is the things. It is the things. If you become a member, can you see the past members only podcasts? You can see the past members only live streams. On Patreon, you can see the past members only podcast. Yes. Past sense of yeet. Eve Barlow got yoted from the courtroom. Yes. Yes. We're going to do just a handful more super chats and get back into the sidebars. Can you copyright claim your clips in the new documentary, or is it fair use? I would have to watch. The reason I did not give Netflix that name is because I don't want to disparage smut. Smut makes me happy. Perry Rush said, liked your channel. They learned you were in EMS. Made sense. I'm a learned you were in EMS. Makes sense. I'm a paramedic and brother is a lawyer. Very familiar. Lived in Nashville before. I did do EMS. I was not good at EMS. I don't do well with smells. So ambulance was not for me. No. But I like the knowledge that I learned. It definitely helped when I went into law when lots of bodies were doing things. EDB is the only reason I like lawyers. My fourth lawyer quit last week and now I'm pro se again. I'm sorry. Family law is family. I wish it on no one. Family law is a tremendously difficult system to navigate. Tremendously difficult. So Sandy said 7-month-old niece loves watching with me. Nugget says hi. Hello, Nugget. Yay, EDB, so delighted you're doing sidebars. The members asked and I said yes. So here we are. Now we have a lot more members and, 18,000 of you in the chat or whatever. Let's do. Will you be doing more sidebars live? Maybe. It depends how many we get through today. What time is it? We got a little bit more time. We've got a little bit more time. And then I have to pack. I should probably check in for my flight at some point. It'll be fine. It'll be fine. All right. We were supposed to go to the next day. I wanted to go to the first page of the next day and see if anything interesting happened in the morning. Because you never, ever know. All right. Did we embiggen it enough? I hope so. Good morning. All right. Before the jury comes out, I want to let you know for planning purposes, I plan to go until 5:30 today because we lost a little time through the week. So we'll go to 5:30 today. Okay, Your Honor. Oh, my nose. Hold on. We gotta take care of the nose for a second. Y'all, it's time for a stretch break. It's time. Give me one margarita. No, I'm teasing. Give me a few seconds. Court's going till 5:30. We lost a little time throughout the week. We'll go to 5:30 today, starting when we come back on May 16th. I want to start at 9 a.m. So we'll be going 9 to 5 through those last 2 weeks just to give us a little bit more of a factor so we can get all of our time in, okay? Bretta Hoff, just 2 exhibitees. It says exhibits, not exhibitees. Defendants 167 and 170, I've already given the court defendants 167 and 170 with redactions. Great. We're still working with counsel on redactions. Great. Anything else? No. Okay. Jury comes in. Great. The court tells them they're going until 5:30. Let's go to the first sidebar. Nope. First sidebar. All right. Let's see. Where are we? Filming of London Fields. Question. So you were filming London Fields and Johnny had gone back to LA. What, if any, issues? Elaine's asking the question. What, if any, issues did you have with him on fraternizing with the cast? I'm going to ask Ms. Bretta Hoff. Michelle, can you pull up Defense Exhibit 188, please? Ms. Vasquez, Your Honor, I'm going to object to hearsay. Bretta Hoff, Your Honor, let's pull up 188A. I've redacted everything but what Mr. Depp said. The court, okay, let me just take a look. Bretta Hoff, that's admission against interest. Hearsay exception. Party opponent. Do you have that? You don't have it? Give me a minute. While they're working on that, can you tell us what transpired between you and Mr. Depp when you wanted to do something with the cast member? And then she answers about that. I already knew I couldn't be photographed, even if it was platonic. I couldn't be photographed with men or women that other people could possibly spin as romantic. I learned that in January the hard way. So I asked him permission if I could go out to this concert with the cast. And I said, Johnny, my co-star, Vasquez, objection, Your Honor, hearsay. And again, this is hearsay because Amber is saying what she told Johnny Depp. She could ask, or she could have testified, and this is Elaine prepping their witness, but she could have said, this was his concern. So I told him I was going, and he responded and said this, because she can say what he said to her, but not what she said to him. They didn't argue that this was background because, again, they're trying to admit what Amber's saying, which she could testify in another way to get the same information in. Ms. Vasquez, objection, hearsay. Question, don't tell us what the co-star said. Tell us your communication with Depp. Objection, hearsay. Her communication are hearsay. And it seems like Elaine is not understanding what the problem is because she could have advised before testimony started, look, you can't tell me I said this to Johnny Depp. You can say, this had been a problem in the past. I knew it was going to be a problem. And when we talked, he said this. And then they approach. Vasquez, she's going to talk about what she said and asking for permission. That's hearsay. Bredehoff, she's on the stand. It's not an out-of-court statement. You got to be fucking kidding me, right? At this point, you're fucking... Am I being punked? Someone is fucking joking me. You've got to be fucking kidding me. Try this on your law school exams. Amber Heard is trying to say what she said to Johnny Depp when she was filming whatever movie in London. And Elaine is saying she's on the stand. It's not an out-of-court statement. She's about to testify to something that was said out of court. Ergo, it's an out-of-court statement. What is happening? How is this happening? I'm taking a screenshot. I'm sending this to Judge Abby. Hold on. I need to make a screenshot. I'm going to forget. Where is it? I need a screenshot of this. All right. She's on the stand. It's not an out-of-court statement. The court, she's testifying to an out-of-court statement. Ms. Vasquez, correct. Ms. Bredehoff, she's on the stand. That's not hearsay, Your Honor. Oh my God. Oh my God. Yeah, you guys, motion for code green granted. Code red granted. This is beyond audacity. This is, you can't launder hearsay, Elaine. You can't say, okay, well, it's an out of court statement, but like, if you say it in court, then like, it's fine, right? Like, even though it's an out of court statement, if you say it in court, then it's an in court statement. No, not at all. All right, if you're new, DEFCON red is flashy. If you're flash sensitive, the flashing stops when the music stops. So we are going to DEFCON red in 3, 2, 1. She's trying to say it can't be hearsay because it's not an out-of-court statement. And she is real fucking wrong. She's on the stand. It's not an out-of-court statement. She's testifying to an out-of-court statement. The court is like, ma'am, this is the definition of an out-of-court statement. The court, what she said out of court could be considered hearsay, but I'm not sure what the statement is that's coming in or what she's going to say. Ms. Vasquez, she asked for permission to go. She asked Mr. Depp for permission to, she wants to be able to go to a concert with her co-star. The court, that's not going to be in evidence. What's the next one coming in? What's she about to testify to? I don't know. Ms. Bredehoff, her communication with Mr. Depp and Mr. Depp telling her he doesn't want her to go. Ms. Vasquez, well, Mr. Depp's statement is not hearsay, but her communication saying she's asking for permission, that's an out-of-court statement. Ms. Bredehoff, she's on the stand, Your Honor. That's not hearsay. She can ask about it. She's subject to cross-examination. That doesn't make it not hearsay, though. Those are separate. Those are separate issues. I can't. This argument would make me bang my head against the bench. How do you even tell your coworkers this happened at the end of the day? Because this is so early on in day 16. How do you even tell your coworkers that this is what happens? She's on the stand, Your Honor. That's not hearsay. She can ask about it. This is how my conversation tonight's going to go with Judge Abby. You are not going to believe what happened at Sidebar. And she's going to be like, tell me what happened at Sidebar. And I'm going to be like, so, defense counsel was trying to elicit a statement from defendant that defendant said to plaintiff out of court. And the objection was hearsay. And she's going to be like, yes, of course. And the argument was that because she's in court now, it's an in-court statement, not hearsay. And then I don't know what's going to happen. I don't know what's going to happen to Judge Abby's brain after I say that. She's probably going to go, what? I'm going to be like, uh-huh. And then she kept doubling down and she's going to go, what? I'll let you know. I'll let you know what she says when I next stream. And on Instagram. Ms. Bredehoff, she's on the stand, Your Honor. That's not hearsay. She can ask about it. She's subject to cross. The court, yeah, she is subject to cross single fucking thing that's said. I'll take them one at a time. That's already in evidence. That's fine. And then we can get into whatever Mr. Depp said. That's fine. But these conversations back and forth, some of them are going to come in for context purposes. Camille said, I understand that. The court said, so we're just going to have to do it one at a time. Right? Because some of it can come in. The court's like, we need some context and completeness as to what Depp said. There's a way that this could have been testified to, though. Did I freeze? I'm sorry. Weird. I shouldn't have. Let's see. Shouldn't have been a freezing issue. Apologies if there was. All right. No, sorry, y'all. That seems to be on YouTube's end. Sorry. That seems to be on YouTube's end. Come on, YouTube. We can stream to 20,000 people. It's fine. Ms. Bredehoff, so please tell us what Mr. Depp said. And then they get into, he effectively said no, that if I accepted the invitation and went out to a concert, that the engagement would be off, that the relationship would be off, and that I was foolish and naive for thinking that people could invite me to a concert in a platonic way. I tried. Look, maybe these were the signs that this was not meant to be. Ms. Vasquez, objection hearsay, because she said, I tried to say that if. Objection hearsay. Ms. Bredehoff, she's testifying about what Mr. Depp said. I don't understand. No, she's not. She's trying to testify to what she said. I tried to say that if. All right, I'll overrule it. He said I was foolish and naive, that no one could invite me to. How could I be so dumb to think that someone would just invite me to a concert? Why would they want to hang out with me? Also, no. Don't know. And that I probably wanted more, I was basically asking for it. You're going to go backstage. What are you going to say to the band? I know how this plays out. Who is the other girl that's going to be there? How could you be so stupid? Just her testifying that he's berating her about wanting to spend time with coworkers. Amber, I'm just going to ask you to stop right there because I'd like you to take a look at Exhibit 188. All right, let's get to the next sidebar. Johnny's kids, Jack and Lily Rose. All right, there was a particular incident that led to a disagreement with Mr. Depp. Objection leading, sustained. What, if any, interaction did you have with Lily Rose that led to an argument with Depp? Objection leading. Ms. Bredehoff, what, if any? Ms. Bredehoff, what, if any? Ma'am? Ma'am, no. The court said, if you could approach. This is early. If you could approach. Sidebar. The court, I understand what, if any, and I get that. But it's all the little extra that you're putting in there. It's a little, Ms. Bredehoff, I'm trying to give context to move along. The court, I understand that. I appreciate that. But I have to sustain the objection based on that, okay? Ms. Vasquez, thank you. You can't lead. You can prep your witness so they know what you're going to talk about, but you can't lead. Ms. Bredehoff, did you have an argument with Mr. Depp relating to Lily Rose in November 2013? Yes. Can you describe that? Ms. Vasquez, objection hearsay lacks foundation. The court, I'll overrule it. This is talking about Lily Rose Depp. We're going to get to the next sidebar. What is this about? Objection hearsay. She's not testifying. She's testifying about context. I'll sustain it. Next question. I'm going to object on hearsay. All right, I'm going to lay the foundation, Your Honor. It's still hearsay. May we approach? Ms. Bredehoff, may I lay the foundation first? Court, go ahead. Yes. Ms. Hurd, did you communicate with Kate James by email in the ordinary course of your business? Yes, I did. She's trying to lay a business records exception for an email. That doesn't necessarily cure the hearsay problem. Is this a communication between you and Kate James? Yes, it is. Your Honor, I'm going to move the admission of 209. Ms. Vasquez, still hearsay, Your Honor. We've gone all that way. And it's Your Honor, it's still going to be a no for me because it's still hearsay. Ms. Vasquez, still hearsay. The court, the business record exception gets the business record in, but if there's hearsay involved inside the business record, then there's still an objection to hearsay. Right? Business record doesn't cure the hearsay inside of an email. But you could get with a business record to the fact that an email was sent. Or you could get to the fact that, transactions happen on a register or whatever. There's a lot of things that can come in with business records. The fact that somebody went to the hospital, but not what the doctor said in the record or the medical exam or whatever. The doctor would have to come in and testify to that. I feel like we're doing a class on evidence. I need to grab my evidence code. Your Honor, the business records exception. I mean, I don't agree. I think that's the point. No, ma'am. The record gets in the record, but if the record contains hearsay, the court, business records exception. Number one, I'm not sure emails are business records. Number two, even if you get business records in, they come in. But if there's hearsay in those business records, that hearsay doesn't come in. Again, the fact that an email was sent, yes. The contents of the email, no. Ms. Bredehoff, Your Honor! Me exaggerating, probably. The court, but if you want to show me something different that says hearsay in every business record come in, please show that to me. Give it to me, baby. Ms. Bredehoff, the exception, one of the exceptions to the hearsay rules is the business records exception. The records of regularly conducted activity. No, that's the foundation. Yes, yes. And it says, I'm on 28036A. The record was made at or near the time of the act's events or calculations or conditions. Right. Monetary records can come in. The fact that an event was advertised could come in. B, the record was made and kept in the regular course of business. The court, keep the record with a regular practice of that activity. This is an email. That's why it doesn't fit with the business record. Bredehoff, that's how she communicated with her. She was her employee. I think for email, you would have to have someone from Google. If it's a Gmail, you would have to have somebody from the company come in and say, these are all the emails. You can't just have the person say, I sent it normally. You would need the custodian of records, which if you watch the Murdaugh trial with me, you would have seen a lot of custodian of records come in. And the custodian of records came in and was like, I'm the custodian of records for cell phone company. And they'd be like, are these your records? And they'd be like, this CD is all the records. We downloaded this. We keep it in our database like this. And when we download it, it's like this. And we downloaded it and here it is. And then you have another witness come in and explain the records to you. And that's a lot of work. But there's rules. For custodian, business records are made for custodian. Invoices, accounting, not people's hearsay emails back and forth. Damn, Judge A. Not people's hearsay emails back and forth. I am forevermore calling them hearsay emails. They will never be an email. They will all be hearsay emails. It is my hearsay Slack message. Not people's hearsay emails back and forth. Neither the source of the information nor the method or circumstances of preparation indicate a lack of trustworthiness. Ms. Bredehoff, why would this not be the court? It's not a business record. It's not a business record. Sustain the objection. Oh, the hearsay papers. The hearsay chronicles. All right, let's get to the next sidebar. Let's back up and see what we're talking about here. Fly back from where? Where were you filming those? New York. Where was Mr. Depp at the time? LA for his movie Black Mass in Boston. So you were in New York and Mr. Depp was in Boston at some point eventually, but in May 2014, that's it. What, if any, discussions or arguments did you have with Mr. Depp relating to James Franco in May of 2014? It's a nightmare. I wanted to do this independent film. I liked the story. I liked the character. I, told him I'm not going to wear makeup in the thing. Objection hearsay. Ms. Bredehoff, apparently the court. Ms. Bredehoff, if we could approach, please. This is not a well-prepped witness. This is not a well-prepped client. We knew that from watching it. It's painful reliving it. I'm exhausted. Trip Hazard said, would emails from a work-issued email address come in? The fact that emails were sent could come in. Depending the context of the emails might come in, but they need an exception. And they would have to come from the custodian of records, which would be whoever hosts the server. So yes, but there are multiple steps. The court. I don't need these side comments. Ooh, it's the apparently. Objection hearsay. Apparently. Damn. Damn. I don't need these side comments. Ms. Bredehoff, I apologize for that. I'm just so baffled. No, you're not. You prepped an entire brief knowing this was going to be a problem. I'm just so baffled. I don't know why. The court, if there's a prior statement that she made, it's hearsay. Unless you have an exception for it, context is not an exception. The court's like, I said what I said. They're arguing the same shit over and over again at sidebar. At this point, I would have lost my mind. I would not have kept my composure. I would be so tired. I'm just baffled. I apologize for that. I'm just so baffled. I don't know why. The court, if there's a prior statement that she made, it's hearsay. Unless you have an exception, context is not an exception. Ms. Bredehoff, state of mind, present tense. She's like an auctioneer. Your Honor, I have hearsay exceptions. Business records. No, those are not exceptions for, quote, I wasn't going to wear makeup. So it's true. Amber Heard didn't wear makeup often. Ms. Bredehoff, I mean, it's context as well, Your Honor. The court, context is not an exception. The court gives Elaine an inch, and she just takes a mile. Ms. Bredehoff, it's not offered for the truth of the matter. Because, of course, context is not an exception. Hearsay is an out-of-court statement offered for the truth of the matter asserted, right? So she's like, I'm not offering it for the truth. The problem is if you're not offering it for the truth, you have to then show why it's relevant. Because if it's not offered for the truth, why the fuck do we need it? Ms. Bredehoff, it's not offered for the truth of the matter. Then what is it offered for? Elaine. Ms. Bredehoff offered to show, well, it doesn't matter whether she's wearing makeup or not, Your Honor. That's not the court. Then it's not relevant. Because it has to be relevant. Ms. Bredehoff, but it's leading up to the argument. It's still context, Your Honor. The court, context. Ms. Bredehoff, prior statement is hearsay unless there's an exception. Context is not an exception to that. Or if it's not offered for the truth of the matter, what is it offered for? It's offered for context. The court, that's not, okay, I'll sustain the objection. Just now we're getting into circular reasoning and the court is like, I'm the fuck out of this conversation. Let's go to the next sidebar. Oh my God, there's like one a page. And these are 4 pages of arguing on the record before they even get to the sidebar. Okay, this is the plain incident. Objection hearsay. I spent a lot of time looking out the window. The court, I'll sustain the objection. because Amber, when she was testifying, was, as there was an objection made, was just talking over the objections. I don't remember if Depp did that too. We'll have to go look at the sidebars of his testimony, I suppose, another time. Objection hearsay. I spent a lot of time looking out the window. The court all sustained the objection. And did there come a time when you tape recorded Mr. Depp on the plane? I went to sit here and say that I was telling myself that I needed to leave him, but as he got worse, he demanded the oxygen tank from the flight attendant. The flight attendant, and he continued to drink and then eventually started howling like an animal and passed out in the bathroom, and the door was locked and was howling. And I, at some point, pushed record on my phone because there was that 5% part of me, objection, non-responsive. You're not asking the question at this point, Ms. Bredoff. I don't think it's not responsive. We know all your thoughts, Ms. Bredoff. She's explaining what led up to the tape recording him and why. I mean, I can ask her. The court, all right, Ms. Bredoff, okay. Why did you record him? Because I know he wouldn't remember what he'd done. I knew he would not remember. Ms. Vasquez calls for speculation. Ms. Bredoff, but she can say why she did it and what she thought. I agree with that. I agree with Elaine on that. But the last part called for speculation. It did. Well, the answer is speculative. Why did you tape record him is an answer. It should have been objection non-responsive because she's offering speculation, but I think the question was proper, and I think Elaine's argument on that was proper. She needed to explain why she took the action, and she can do that. You can say, why did you tape record? She said that. Y'all are just put out with her at this point, which I understand. You can just say, oh, this is Elaine rephrasing. You can just say, why did you tape him? In my experience, when Johnny was inebriated, he would not remember what he had done. Ms. Vasquez calls for speculation. Ms. Bredoff, how can that call for speculation? The court all sustained the objection because it's somebody else's state of mind. All right, let's go to defendants 221. If the answer had been, I taped him because I wanted to show him how he was acting. I wanted him to hear what he was doing. I wanted him in the morning to know what had happened. I was worried he wouldn't remember. That would have been fine. But again, Amber Heard's testimony is talking about what Johnny Depp is thinking, not what she was thinking. I was worried he wouldn't remember. I wanted to show him in the morning. She needed to testify about her, not about him in these moments. And that is the problem that they are running into. And that is something that I don't think her lawyers did a good job at. I think they did her a disservice because they didn't explain to her, you need to talk about you. We'll get to him, but you need to testify what you saw, what you thought, what you did, what you heard, you, not him. And that's why they continue to bump up into these. Your Honor, may we approach? Oh, wait, did I jump pages wrong? No. The court also sustained the objection. All right, let's go to defendants 221. I'm going to play 3 different parts from it. Your Honor, may we approach? The court, okay, 221. Ms. Vasquez, so I anticipate this is the Boston plane recording. The court, it seems like it. That's where we are. Yeah, you've read that correctly, Ms. Vasquez. Ms. Vasquez, yeah, so there are other voices in this recording beside Mr. Depp. The court, okay. So I asked that those voices, the court, the clips you have aren't with other people's voices, correct? The court telling Ms. Bredoff how to answer. If somebody ends a sentence with correct, it generally indicates that they want you to not fucking do that. The clips you have aren't with other people's voices, correct? Ms. Bredoff, one of them is yes. Wrong answer. The first 2 are of him howling, but Your Honor, that doesn't, she's authenticated that. She's made the recording. The court doesn't matter. Hearsay can still be involved in tapes too. I can read the sass. Elaine, just because it's recorded doesn't mean it's not hearsay. She's authenticated the recording. Same as the business records, Elaine. A properly authenticated business record doesn't mean there's not hearsay inside the business record. Law is real fucking tedious sometimes. The court doesn't matter. Hearsay can still be involved in tapes too. So the other people in there, you're trying to get their statements in, that would be hearsay. Ms. Bretterhoff, I'm not offering that. The court, okay. For the truth of the matter. So you are offering it. The court, what do they say? Ms. Bretterhoff, he says he's going to stay with this fucking idiot until in case he gets sick. But I'm not offering that. I'm offering what's going on with the howling. So someone else on the plane calling Depp a fucking idiot is hearsay unless you call that person to testify. The court, I'm going to sustain that statement. Ms. Bretterhoff, then the first two I'm offering, the first two are just him howling. Is that right? Howling? Is that what we're talking about here? The court is like, what the fuck is happening? The court, so just him howling and there's no other sounds or just her? Ms. Bretterhoff, no, I don't believe so. Jerry Judge is just on the third. And Jerry Judge is deceased, so cannot come in and testify, so none of that comes in. The court, so you're just going to do the first two. The court is asking it as a question, but telling. Ms. Vasquez, that's fine, Your Honor. The court, so you're not going to get the whole thing in. We're just going to call the first one A and the second one B. Is that okay? So A is going to be Bretterhoff 0 to 1 minute. Okay, B will be 250 to 320. The court, okay. Then after we hear those audios, why don't we wrap our morning? Great. Ms. Bretterhoff, back to open court. Thank you, Your Honor. Open court. Ms. Bretterhoff, so we're going to start with 221 and we're going to call it A, and there will be 0 through 1 minute. Your Honor, may I approach? You were just at sidebar. Ms. Bretterhoff, I think all three of them have already been admitted into evidence and were played during Mr. Depp's cross-examination. The court, do you have any of the audio? I don't remember the numbers, so you have to tell me which numbers they are. Ms. Bretterhoff, yes, it's already been played, Your Honor. It was played during Mr. Depp's cross-examination. Not with Jerry Judge's statement, it wasn't. The court, not the third one, because they said Jerry Judge is in the third one, and I have not heard any recordings of other people. Mr. Nadelhoff, remember during his, we can check at the break. The court, you can check, but let's just do those two now. How about that? Nadelhoff, fine. Bretterhoff, we're going to start with the first one, 0 to 1 minute, and then you can turn up the volume. That's part of it. The noise on the airplane is a little bit loud. We'll be able to pick up the noise. And then they play the audio clip, Mr. Depp moaning. Now we're back to sidebar. Mr. Bretterhoff, I think Your Honor would torture the jury if I did that. Hold on. 221 is in evidence. All of 221 is already in evidence. So may I play the third one then? And then we can take the break. Yes, you can play all of it if you would like. Ms. Bretterhoff, I think that would torture the jury if I did, Your Honor. 9:30 to 10:30 seconds, whereupon the following audio clip is played. Unidentified male. I'm going to stay with this fucking idiot in case he gets sick. The court, all right. And you're going to be changing gears after that. Oh, they're at sidebar. Where did they? Oh, this is where they went to sidebar. All right, they're still at sidebar. Talking about this. Sorry. Ms. Bretterhoff, no, I think this would be fine for a break. The court, all right, ladies and gentlemen, we're going to break. Did they play that? I'm so confused. When did they go back to open court? They didn't say they went back to open court, but I think they did go back to open court and played that. I'm going to have to go back and watch this part of day 15. I truly don't remember. All rise, recess is taken. All right, are we ready for the jury? No, may we approach? Sure, Your Honor, I'm going to have a series of text messages. Okay, I think that was outside the presence of the jury, all of it. The court, okay. Bretterhoff, emails. So I thought I would just head it off. The court, sure, that's a great idea. If you're going to try to get into more emails, you're not going to. Looking at Rule 2803, the court, hearsay exception. Ms. Bretterhoff, it says the following are not excluded by the hearsay rule. The court, right. Even though the declarant is available and we've got admission by party opponent. The court, right. We've done that. Ms. Bretterhoff, we have present sense impression. The court, right. I understand. I'm very familiar. Ms. Bretterhoff says, I accept that, Your Honor, but and business records is also in the hearsay exception. I'm going to be putting a number of them, and I'm going to be arguing with each of them that it is present sense impression and then existing state of mind, but I'm going to put them in. I need to put them in, even if Your Honor rules against them. That's not how that works. Anything you identify as part of the record, you can't put them into evidence. It's part of the record. Ms. Bredehoff, I understand and I fully appreciate and respect Your Honor has the right to rule however Your Honor wants to. The court, yeah. Just want to give you a heads up on that. So they're just going to fight again? Great. I think what Elaine is trying to say is that she wants to preserve the record for appeal, and she wants these exhibits marked as exhibits. So when we're coming to evidence, you can mark something as an exhibit, and then you can admit it to evidence. If it's admitted to evidence, it can go back to the jury, and they can review it, and it all can come in. But if you just mark it as an exhibit, then you have it marked in the record and the appellate court can read it, but you don't show it to the jury. So you can mark it as an exhibit without admitting it into evidence. And so I think she's trying to say that she is that she is trying to preserve it for appeal and she wants them marked. Okay, they're marked. And the court's like, okay, they're marked. Great. The Miss Bredehoff, I just want to give you a heads up. We're going to fight about this more. Great. These are my predominantly the two exceptions I'm relying on with this series. There are some that are just spontaneous. Some of them are even they're saying, the court, I'll have to look at them one at a time. Bredehoff, I appreciate that, Your Honor. I just kind of want to preview. The court, thank you. Vasquez, thank you. Open court. All right. The jury comes in. They get one question. And then I'm going to take you to look at defendants 204, if you can bring that up. Objection, Your Honor, hearsay and leading. Ms. Bredehoff, Your Honor, I would direct Your Honor's attention to the first one in blue. The court, okay. And the third one in blue, and I would say present sense impression and state of mind at the time. The court, all right, if you want to approach. Which means that the court's going to try to explain it to Elaine again. The court, all right, so I'm going to overrule it as present sense impression. Again, it's past. Present sense impression has to be happening at the time. If she called from the plane and saying he's kicking me, for example, Ms. Vasquez, overrule or sustain? The court, sustain. I mean sustain. He's kicking me. Sorry. Thank you. He's kicking me. Those are present sense impressions. Ms. Bredehoff, Your Honor, I need your help. JD. The court, yeah, JD. He is passed out on plane. Ms. Vasquez, but she says here, I'm headed to the court. That's the one I'm talking about, that one. So I need your help. Ms. Bredehoff, yes, I think that's state of mind. That's mental state of mind at that point, Your Honor. When are these texts? This text is at 5:24, and right before that, Ms. Vasquez, she's already off the plane, Your Honor. She says she's heading to AD. AD is one of Mr. Depp's residences on Sweetser. Ms. Bredehoff, Your Honor, the cases that we cited, even on the excited utterance and the present sense, it says it doesn't have to be immediate. It can be after. Clearly, it's state of mind. So now she's citing the case law, but I need your help isn't state of mind. Unless you're saying, I need you to help me. I am insert state of mind. The court, well, the cases that you have, she already has been assaulted and then she was calling and giving a license plate number. Ms. Bredehoff, that's one of them. That's correct. That's like immediately past, though. The court, she's already off the plane. She's testified that on the plane, she was sitting looking out the window. Ms. Bredehoff, it's state of mind. I need your help. The court, she said she was looking out of a window at the time when and then she was off the plane. Ms. Vasquez, and she recorded him. The court, then she recorded him. Just the window of her state of mind. So I'm going to sustain the objection, both of these, okay? Thank you, Your Honor. Thank you, Ms. Bredehoff. All right, let's go to 205. Defendants 205. By Ms. Bredehoff, this is a communication between you and Rocky Pendleton, your best friend. Is that correct? That's correct. Objection, hearsay. Have we learned nothing? This was frustrating to watch. It's more frustrating to read all the sidebars. My nose is angry at me again. I need 30 seconds. It might take a minute more. I'm sorry. You guys are going to have to stretch break. I'm going to mute my mic though. My nose is objecting. My nose is objecting. All right, I remembered to take care of my mic that time. I did like a real adult job. It yeeted me. I don't know what happened. Good Lord, y'all. I got yeeted. I need to bring my screen back up. I don't know what's happening. That was me. I don't know how I did that, but that was me. Good Lord. Can we stream, please? Can we be great? No, something is bugging my nose. Probably dairy, but we're making it work. The timing was so spicy. Me being like, hey, I made something work. Yeet. Goodness. All right, y'all. We are going to try to get through these. And then I have got to yeet. Honestly, that was spicy. Okay. The court. Objection hearsay. All right. Do you want to approach? The court at this point is exhausted. I was like, fine. Do you want to make your responses for the record? Ms. Bredehoff? Yes, Your Honor. The I'm not good is clearly a state of mind, a mental condition at that point. JD is drinking again and using some new round of prescription meds. He just freaked on me bad. Never seen him like this before. It's worse than I've ever seen before. It's over. Maybe not forever, but we're definitely on a break. That's also state of mind. It's also present sense impression. Some of that is past. I think some of that is state of mind. I think the I'm not good and he just freaked on me. Never seen him like this before. It's worse than I've seen before. It's over. Maybe not forever, but we're definitely on a break. I think some of that is her mental state. Like she thinks they're on a break. The court, so I can see the argument there more so than the other ones. The court said, I'm going to sustain as to present sense impression. Again, it's after the fact, and she's talking about this. What she says happened. And you're saying the first one, I'm not good, is her state of mind. Ms. Bredehoff, definitely state of mental mind. The court, all right. What's your response to that? Ms. Vasquez, it's vague. I'm not good. She could be not good in a lot of senses. There's no context. I'm not good. All right. So state of mind must relate to a mental state that is relevant to the litigation. The court says, how is this relevant to the litigation? Ms. Bredehoff, after being abused, she just got off a plane and she's not good. That's highly relevant. He's saying that he never abused her and that she abused him. Ms. Vasquez, she doesn't say she was abused. She says, I'm not good. I think that's splitting hairs on it. And the court allows it. Yeah, the court, I'm going to overrule the objection to I'm not good, but I'm going to sustain this to the last one. Okay, thank you. So I think I'm not good is fair to interpret as I'm not doing well. Like I'm not okay. I think that's fair. Thank you. This needs to be redacted. So they redact it back in open court with the texts back and forth between Rocky Pendleton. Oh, hold on. My document just froze on me. Give me 1 second. There we go. And I'm also seeing Abda in the chat. Today is the day ragweed releases its pollen. Rude. I'll take some Claritin after the stream. It might be that. So they go back to open court. talking about Rocky Pennington. And then Amber Heard said, I was scared. Did you text your mother and your father about this incident? Now, if this had not been a total shit show, Camille could have waited, because that should have been yes or no. But Camille at this point does not trust that Amber Heard is not going to launch into what she said. So that's why she's objecting at this point. Objection, hearsay, the court, if you want to approach. If you want to. And then instead of approaching, and instead of waiting for a ruling, Elaine just launches into another question, trying to fix it. What, if any communication did you have with your mother and father following this incident? That question's actually worse. That one elicits hearsay. The first one actually elicits an answer. Did you communicate with your mother and father after this? Yes. Fine. That's it. I communicated with people. Why did you communicate with them? I was upset. That's fine. So she tries again with what, if any, and asks a worse question. Objection, hearsay, sustain. Let's go to defendants 222. And Your Honor, I suspect we're going to be back up. The court, do you want to approach? The court, all right. So the one from the father is obviously hearsay, right? The court's like, Elaine, you know this, right? Like, you know that the text from her dad is hearsay. Like, you know that, right? Ms. Bretterhoff, yeah. The one I'm looking at in the blue box, that is state of mind and present sense impression. She's going through and recounting what transpired. We already talked about past. The court, and when was Ms. Bretterhoff? This was at 5:24. The court, so you're saying present sense impression for all of this. Ms. Bretterhoff, yes. It's describing what transpired. Transpired being the operative word, because it's describing what transpired, not what's transpiring. And then it's also state of mind. It's how she's feeling about this and her struggle. Vasquez, after the fact, Your Honor. Passed. Ms. Bretterhoff, even after the fact, that doesn't take out state of mind. The court, present sense impression is not after the fact. It's a present sense. Mm-hmm. I feel like the court wants to hold up a sign and just be like, present means in the present. Present, happening now. The giving a license plate is a really good example, because when you are calling and like, I'm looking at the car right now, the license plate is blah, 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 blah. That's happening contemporaneously in the moment. Ms. Bretterhoff, it's state of mind. She's saying where she is and how confused she is. The court, I'm going to sustain the objection to this. All right. Thank you. Thank you. Thank you. Back in open court. Let's see how far we can get till the next sidebar. Not far. Let's see. That was page 21. This is page 22. And down here at the bottom, you can see the page numbers. They got maybe one question. I remember how painful this was. Ms. Bretterhoff, Your Honor, may I approach? Sure. Ms. Bretterhoff, I think all three of them have already been admitted to evidence and were played during Mr. Deck's examination, cross-examination. The court, do you have any of the audio? I don't remember the numbers, so you have to tell me the numbers. Ms. Bretterhoff, yes, it's already been played, Your Honor. It was playing during Mr. Depp's cross-examination. When the court asks you for the numbers, what you need to do is give the numbers. Number 107. Yes, it's already been played, Your Honor. Not the third one, because they said Jerry Judge is in the third one, and I have not heard any other recordings of other people. Okay, this went backwards. All right, let's go forwards. Sorry, that was me, because now we're on page 22. I went back too far. Damn it. Recess taken, all rise. Ready for the jury. No, may we approach? Sure. Your Honor, I'm going to have a series of text messages. We did that one. Did I go back too far? All right. How did I get backwards? That was the next present sense impression. This is the communication with Rocky Pennington. They fight about the present sense impression. Okay, this is where we were. This is another fight over, there's like 5 of these over present sense impression. Now we're back to business record exception. All right, if you want to come forward, we can do that. The court, let me just read it. You're saying the text message is business records? Ms. Bredehoff, yes, with her employee. You would have to get those from the cell phone carrier, ma'am. Ms. Bredehoff, yes, with her employee. She's talking about the hotel arrangement. She's asking her to book her on a plane, which is what her role is. She works for her. The court, but that, Ms. Bredehoff, redirecting her text, etc. So it's a business record. No. No. Mm-mm. No. This isn't how this works. This is not how you get in text messages unless the two parties have decided. And even if the two parties have said yes, text messages, screenshots from their phones, all of that can come in without bringing in the custodian of records. Even if they agreed to all that, which you can do. What you can't do is admit hearsay just because it's in a text message. Hearsay text. But Your Honor, the exception says it's a business record exception. That's an exception to the hearsay rule. The court, it's an exception, but it also says, I can read it to you. If there's any opinions in it, then it has to cover that hurdle. Ms. Bredehoff, but the court says, and this is clearly all opinions in here. It's bad. It's worse than ever. Wow. Judge A, it's bad. Real bad. Judge A's like, this is the worst of the hearsay, and we've had a lot of fucking hearsay. It's worse than ever. Those are all opinions. Even if you get it in as a business record, none of the opinions come in unless you have another reason. Ms. Bredehoff. So here's my other question. She's just jumping topics, hoping the court will forget. Kate James has testified and was allowed to testify. The court, I can only handle the objections that are brought before me. Ms. Bredehoff, I understand. She testified because it was an admission against interest. The court, right. She said Amber Heard, was having a great time, wasn't worried about it, never said anything to her. Can't I do an impeachment on that? Fucking hell. No. You have to impeach the person. You have to impeach Kate James. You can't impeach Kate James's testimony if you don't ask her about it. The court, Miss James is not on the stand right now. Miss Bredehoff, but she was a witness and it could be impeached. This has gotten to TikTok psychic levels of, but they were students at the university. It's plausible. The court, you can only impeach the person that's on the stand, okay? See, you can impeach the person on the stand, and then you can ask another witness about it to back it up. But if you don't impeach the person on the stand, then you can't get into it. Oh my God. The court, you can only impeach the person on the stand, Ms. Bredehoff. Okay. The court also sustained the objection. Ms. Bredehoff, so what, if anything, did you do on the evening of May 24th? Great. Next, let's see. We're on page 26 of 78. Oh, never mind. There's the next sidebar. 2 questions later. I'm going to ask you now, turn to 225, Ms. Bredehoff. And Your Honor, I'm going to be referring to the last 2 blue spots on the page with the state of mind, mental condition. The court, all right. Ms. Vasquez, it's still hearsay. Your Honor, may we approach the court? Yeah. Would you want to approach? I just want to make sure I get the right context. Sidebar, which ones? The last 2. Yep, the last 2. Crying. The court, she's sending them in 2 separate texts, all right? Crying my eyes out. So now this is Ms. Bredehoff's state of mind? This is supposed to be, she's trying to get to present sense impression, crying my eyes out. Like it's happening now, but it's not an impression of something else. It's a description of her own behavior. So Ms. Bredehoff, state of mind. The court, after dinner. Ms. Vasquez, after dinner when she's at the hotel. The court, we're losing context here because this is after she took the daughter out. Ms. Bredehoff, well, true. Stop there. It's after what remember that Kate James testified. A dog with a bone, this one. Remember, Kate James testified she was having a great time. She was consuming and no big deals, and she wasn't upset at all. And this is what she's expressing to Kate James, that she's crying her eyes out, which is her state of mind at the point she's crying her eyes out. What you needed to do is say to Kate James, didn't Amber Heard tell you that she was not okay? She's crying her eyes out. She's very upset. The court, but you're trying to relate it back to the time on the plane, to her state of mind. State of mind needs to be contemporaneous. Ms. Bredehoff, sure, she's still upset. It just didn't go away. The court, I'll sustain the objection. Thank you. Ms. Vasquez, thank you. Open court. Ms. Bredehoff, I'm going to turn now to 228. Ms. Vasquez, Your Honor, we're going to object on hearsay. Oh my God. If you want, Ms. Bredehoff, the first line, Your Honor, it's all understanding Your Honor's ruling, but I think the court, all right, if you want to come forward, that's fine. The court, all right. State of mind? And is this? Ms. Bredehoff, I need your help. I think that's clearly state of mind. The court, I think Ms. Bredehoff at this point is asking the court for help. I'm teasing. Ms. Bredehoff, that's clearly state of mind. The court, how is that her state of mind? I got the other one in. I understand that. Ms. Vasquez, I believe you just sustained an objection to the same type of text message. The court, I understand. Ms. Bredehoff, actually, I thought the I need your help to Rocky came in for precisely that reason. Ooh. Now we're getting snarky. And Elaine's like, you let the other one in. What's the difference with this one? Which is a fair question. What's the other one? What's the difference? Actually, I thought the I need your help to Rocky came in for precisely that reason. The court, well, she's had just gotten off the plane. Is that where we're at now? Or is this after dinner again? Ms. Bredehoff, 7:57. On what day? The 20th? 4th. The 24th? To her sister. That was sustained. I still think it's her state of mind, Your Honor. She's saying, I need help. The court said, so you're just trying to get I need your help. Ms. Bredehoff, right. Recognizing I would like to get all of them. The court, no, I understand that. Ms. Bredehoff, I fully appreciate Your Honor's ruling. Do you, though? I feel like you don't, though. I feel like you don't. The court, a statement of the declarant's then existing state of mind, emotion, sensation, or physical condition, but not including a statement of memory or belief to prove the fact remembered. The court's now reading the evidence code. Then existing state of mind, emotion, sensation, or physical condition. Help, I've broken my leg. Oh my God, I'm scared. But not a memory or belief to prove the fact. Ms. Bredehoff, that's not a memory. I think that's clearly a state of mind. I need help. Your Honor, you just sustained the same objection to I need help. To Rocky Pennington, it's the same thing. It's honestly the same message. The court, it is the same message. Ms. Vasquez, this is what she did. Ms. Bredehoff, this is what she did. Ms. Vasquez, doesn't matter. The court, I don't see I need your help. I'm going to state of mind. I'm going to sustain the objection. Ms. Vasquez, thank you. Ms. Bredehoff, present sense impression? The court noted for the record. What that means is you're dismissed, and I note the objection for the record, but stop it. Ms. Bredehoff, so tell us, please tell the jury what you did then overnight the next day at the hotel. I cried a lot. She's allowed to testify that she cried. She can testify to what she saw, what she did, what she felt. She can't testify to what she said to other parties. Those parties can come in and they can testify to what they saw and felt and heard, but not what she said to them. I'm tired. We're not even getting a page without an objection. And this transcript is 78 pages long. And we're on 28. Y'all. Which is why we're almost 3 hours into this stream. Objection hearsay. Your Honor, let me ask it this way. What, if any, communications did you have with Mr. Deuters? Communicating on behalf of Mr. Depp. Objection hearsay. I would say agency on that, ma'am. The court, you have to lay a foundation for that. All right, let's go to 229A. And could you, without saying what the content is, could you tell us who this text message is with? Johnny's assistant. What's his name? His name is Stephen Deuters. Okay, what, if any, communication were you having with him following the Boston plane incident? Objection to hearsay. May we approach? The court. All right. Yes, you may. Ms. Vasquez. So I'll let Ms. Bredehoff. The court. What was your objection first, Ms. Vasquez? My objection is hearsay, Your Honor. Very few employees are hired to be speaking agents. Mr. Duders, while acting as an assistant to Mr. Depp, was not in charge of communicating with his then girlfriend, fiance, and statements on speaking agents only on matters within the sphere of their responsibilities, the court, and during the term of their employment. Ms. Vasquez, and during the term of their employment. So again, if you hire someone to speak on your behalf, they could be an agent, and then the statements that they make on your behalf are like attributed to you. That's not what's happening here. The court, I understand that. Ms. Bredehoff, he says here, he's teary. He doesn't want to be a fuck up anymore. His words. Those actually aren't Johnny Depp's words. Those are Stephen Deuter's words. And I believe they could have called Stephen Deuters to testify. But they didn't. His words. And he testified in his deposition, Your Honor will remember, we showed you that Mr. Depp told him to reach out to Amber. Then he has to testify. But I have a feeling that if he was called to testify, what he would say is that he was placating and he was trying to negotiate the fights between the two. And there's a reason they didn't call him to testify. They could have. They didn't. Why not? The court, depositions aren't foundation for here, okay? Not the rules. So if you had him here to testify and he told him to say that, so we should wait until later on these, Ms. Bredehoff says. Only if you're going to call him to testify, Elaine. The court said, okay, I didn't rule. So it wasn't part of the designation. Ms. Vasquez, no. So his deposition is not coming in. Ms. Vasquez, correct. Ms. Bredehoff, I'm not positive we won't put it in, Your Honor. The court, we can't. The depositions are done. Ms. Bredehoff, I understand. Again, depositions are done in this case. Ms. Bredehoff, I understand. The court, that ruling isn't happening. Oh, boy. Oh, boy. That ruling isn't happening. Oh. Stop trying to make fetch happen, Elaine. The court is not having it. You keep trying to make fetch happen. Fetch is never going to happen. I guess we know why it's not coming in. That ruling isn't happening. Ms. Bredehoff, I understand. Ma'am. My argument here is for the entirety of 29, which goes from 29A through M. It's admission by a party opponent, a statement by the party's agent or employee made during the term of agency or employment concerning a matter within the scope and agency of their employment. The court, right. That's what I have here. I understand that. But I don't see the foundation for that. Only matters within the sphere of their responsibilities and during the term of their employment. Ms. Bredehoff, so if I lay a foundation that she's communicating with him, the court, you've already said that. You already laid that foundation. Ms. Bredehoff, he's an employee. The court, it doesn't. Ms. Bredehoff, the deposition testimony on this, that's not evidence. The court, you're saying as a personal assistant, it was his realm of employment to text the girlfriend of his employer? Ms. Bredehoff, that's what he testified. No, that's not before me. Ms. Bredehoff, yes. No, Elaine, no. Ms. Bredehoff, yes. The court, I'll sustain the objection. Ms. Vasquez, thank you, Your Honor. Ms. Bredehoff, but I'm sorry, which one? 229 for the record. I want to make sure I get them. A through M, the court, N. Bredehoff probably goes back to M. M as in Mary. M as in motherfucking hell. What is happening here? M for might bang my head against the desk. M as in Mary. Okay, back to open court. All right, back to open court. How far do we get before the next sidebar? We are right now on page 29 of 78. Wait, no, that went backwards. We were on 12. We went from page 29 to page 26. That's not right. Okay. From page to 27. This one we already did. Darn it, it jumped on me. 14. Hearsay, that's not an employee. 15, we're almost done. Yay, we're on page 60. What is happening here? The bailiff. Okay, so the recess was taken for the afternoon. The bailiff, all rise. Okay, all back. Okay, before Your Honor, the court. All right, before we get to the jury, I just want to see talking with Sammy is Friday, May 27th. We don't usually meet on Fridays. But is it an okay day to have trial on that Friday? It's the Friday before Memorial Day. I want to check with the jury, but I want to check with you first. That will actually be closing argument day for anybody that wants to know. So I want to make sure I keep track, but if that's good with the jury, I just want to make sure, Bredehoff, that works. Your Honor, that works. May we approach? Sure. So this is before they come back from the lunch break. So, Your Honor, perhaps the witness misspoke. What is happening? But she did say that yesterday or the day before she looked at some photographs. I just wanted on the record that clear instruction is given to her, especially in light of the break that we're having, that she's not supposed to be talking to the attorney about her testimony. Totally didn't happen. That she's not supposed to be talking to the attorney about her testimony. Perhaps she misspoke, but she did say that she looked. I assume she saw them before she was on. Ms. Bredehoff, she did. She misspoke. You didn't even check with your client, Elaine. How do you know that? Ms. Vasquez, at the end of the day, I'll do that again, but I don't need her commenting on the evidence or evidentiary issues. That's the second time it's happened. Ms. Bredehoff, I realize that, Your Honor, but I can't talk to her. The court, I know you can't talk to her, but you can tell her not to talk about evidentiary issues. That's not her testimony. Ms. Bredehoff, okay. The court, don't you agree? Ms. Vasquez, yes, Your Honor, and that's why I wanted to raise the court. If you want to talk to her about that right now real quick or something, I just can't talk about things in front of the jury that we discuss outside the jury, and there's a reason we do things outside the jury's presence. Ms. Bredehoff, okay, I'll let her know right now. No, she's just trying to slide it in. That's why those side comments are happening. Depp made them too. Both of them were making side comments that shouldn't have come in, but both parties did it. Open court. All right. I mean, most of the time when Depp did it, it was elicited by Rottenborn. So they were sniping. These are being elicited on direct. The court. All right. Thank you. Have a seat. All right. Let's see. Sidebar 15. Sidebar 16. 2 pages later. Miss Vasquez, objection. Lack of foundation. The court, all right, do you want to approach? This is with regard to a recording, another recording. All right, the recording, Your Honor, is 5 hours long. What? She's not there for most of it. It's other people's voices, the court. So I guess the question is, how can she say the whole thing was accurate if she wasn't there the whole time? Ms. Bredehoff, I'm trying to indicate that the court, are we going to move it in? Ms. Bredehoff, don't we already have parts of it in? Ms. Vasquez, we do not because there's other voices. The court, well, let's do that now. Are you moving it in? Ms. Bredehoff, yes, I'm moving in parts of defendant's 378. The court, what parts are you moving in? You're not moving in all 5 hours to this jury, are you? You're not moving in all 5 hours to this jury, are you? Ms. Bredehoff, no. The court, but the parts you have, are they just, Ms. Bredehoff? They are other people. They are absolutely other people. I don't understand why that wouldn't be admissible. Ma'am. Hearsay is why. Hearsay is why. Ms. Bredehoff, if I'm understanding, it's not hearsay to see videos. The court, no, videos aren't statements. Videos are pictures, Ms. Bredehoff, but recordings aren't statements here. The court, if there's hearsay inside the recordings, it's hearsay. Ma'am. But Your Honor, videos are like moving pictures. Videos can be shown without the sound, Elaine. Audio can't. If there's hearsay inside recordings, it's hearsay. Ms. Bredehoff, all right, well, then I'm moving to admit them and the court moving to. I'm moving to admit the recording, but I guess Your Honor is going to deny. But Elaine, or Vasquez, objection, hearsay. The court, The objection's hearsay. I'm going to sustain the objection. Miss Bredehoff, can you tell me the number of that exhibit so I can? 378. Thank you. Thank you. Yikes. All right. Let's see. Last sidebar for day 16 of trial. Let's see what the context is. Oh, that's a long soliloquy. Everything in bold is the witness testimony. So let's go to the island for the Christmas holidays. And what, if any, arguments did you have with Mr. Depp at the island over the Christmas holiday? And then they're talking about that. He just made a promise that he was clean and sober. We had horrible thing happen in December. I thought we were moving forward. And the third time this happens, I jump up. I already changed my pants twice. I jump up and shout at Johnny, like, what are you doing? Or Johnny, you spilled it on me again. That's hearsay. Something to that effect. And I get up off the couch, and Johnny's son says, how do you know to look for hearsay? Whenever somebody says. You guys, thank you for the gift of memberships. B2, that's tremendously generous. You're always so generous with memberships. Thank you. Eric Newman, thank you for the memberships. Mary Richard, thank you for all of the memberships. Y'all, that's so generous. I know others have gifted them too. Thank you so much. That's incredibly kind. Thank you, chat. Charlotte, chat is always on fire. Chat is bae. If you can't see who's talking, it's not hearsay. Elaine's rules of evidence. Elaine's rules of evidence. The Elaine code. Oh my goodness. Ms. Vasquez, Your Honor. Hearsay. Ms. Bredehoff, Your Honor, not offered for the truth of the matter. It explains, if you could approach, the court's like, stop saying it in front of the jury and come to sidebar. The court, I just don't know what the statement is, so I can't say if it's for the truth or not of what did his son say. Ms. Bredehoff, his son's going to say, do you need any help? She's going to say she looked pointedly at Johnny and said, no, thank you, Jack. And then she went in to change. And that's when he came after her. So it fits that she said, no, thank you. The court, so you're saying hearsay. Ms. Vasquez, hearsay. The court, why are you saying it's not? Clearly looking at Ms. Bredehoff. It's not offered to prove the truth of the matter. What he said, the fact that he said, do you need some help, is not offered to prove the truth that he wanted to help her. The court, what's it offered for? To show the chain that she says, no, thank you. And that she looks at Johnny. And that's what sets him off. And then he beats her up. The court, well, then it's for the truth of the matter. I don't agree with the court on that. She's trying to get it in for context. Well, but it's not, because Jack is saying, do you need some help? The court, all right, I'll overrule the objection. Okay, thank you. Amber, please continue. Jack said, are you okay or can I help you? So I don't think they're offering it to prove he wanted to help. So, and then there's a fight. And then Ms. Bredehoff, this is a good breaking point. The court gives the jury instructions at the end of the day. Gives instructions to Amber Heard at the end of the day. The attorneys, I won't see you tomorrow for Friday depositions because we finished them. I want to thank you all for last Friday staying here until I think it was 9:00 at night, but we got them all done. I appreciate your work on that. Then the court goes over scheduling. Our afternoon break will probably be between, 3:15, 3:30, maybe even a little later. We'll see. And then we'll try to break at 5. There may be times when we go to 5:30, as I told the jury. So I just want to make sure you know that. Since I won't see you tomorrow, I want to go ahead and give you your times as of this very minute. Mr. Chu's going to try to do with a highlighter. That's sweet. There we go. That's right. All right. So the plaintiff has used 35 hours, 6 minutes. Defendants, 36 hours, 31 minutes. So the defendants are already over by an hour at this point in the middle of Heard's testimony, which means plaintiff has 26 hours, 9 minutes. Defendant has 24:44. Just a reminder, as we said from the very beginning, once your time is up, your time is up. If it's in the middle of the witness, I'm going to stop you, okay? So make sure, the 9 to 5 schedule, when he starts back May 15th, will give us a little buffer, but not much. Enjoy the week. So other than that, does anybody have anything else for me? Ms. Bredehoff, yes, Your Honor. It's just a math question. Lawyers. I think we have 25:44 as opposed to 24:44. The court. Sammy says 24. Ms. Bredehoff, they have 35 and we have 36. The court, if you add up 36 and 31 and 24 and 44, you get 61.75. The court, you get what? Ms. Bredehoff, what is our allotment? Is it 61? Ms. Bredehoff, what's the total that we've got? What's the what? The court said, what's that? What's the total that we have? The court, 61 hours and 15 minutes. Does that add up then? That's right. Mr. Rottenborn says I'm right. Because he must be nodding in court. And the court's like, Elaine, Rottenborn says I'm right. Judge A is like, Rottenborn says I'm right. Okay? Listen to Stanford over there. So that's the right time, Ms. Bredehoff. Thank you. The court, Sammy did it 3 times over. So I thought that was right. You made him very nervous. Okay, that's good. Everything else? Anything else? Yes, ma'am. Ms. Vasquez, Your Honor, we do have an updated exhibit page, and then they give the exhibits, and that's it. That is the end. That is before they take that week-long break. And that week-long break is when the PR teams were like releasing statements like crazy. There were so many statements that came out to PR. Let's get to questions real quick. We are over 3 hours, and I'm going to have to break because, well, I have to pack, and I have things. But we're going to do some Q&A real quick. Don't worry. Don't worry. That's not what I meant to do. Y'all, there are more sidebars. And we have a lot of cases we're behind on and a lot of things to catch up on. But I'm going to put up a poll. Do we need, for the 16,000 of you here, do we need to do one more sidebar stream? Let me just ask. We're putting up the poll. Do we need to do one more sidebar stream? Let's get to a few questions. This was spicy. Was it not? Marty, thank you. Question, Elaine keeping acting against Judge A's objections and ruling. Could Judge A point to contempt of court? That would have had to have been done at the time. Judge A would have said, if you keep doing this, then it's a problem. There is a process for that. So Judge A would have had to have done that at the time. So I see a lot of you saying you want to see the sidebars during Amber Heard's cross-examination and redirect. Okay. So we'll do day 17. Let's see what the poll says. 97% of you say yes. We're not just, you guys aren't tired of this trial? Really? Okay. If you're not tired of the trial, then you're not tired of the trial and we will do it. Get some more salted caramel before the Chiefs game Sunday. Also got some root beer. Yum. Sadly, no salted watermelon. Well, you're ready with the salted caramel and the root beer. The root beer is so good. If I'm on the stand, can I tell the court what I said, or is that still hearsay? You cannot say what you said, what you did, what you saw, what you heard. Just think of anything in your life. Most things can be done with what you saw, what you did, and what you heard. You don't generally need to explain that you said to somebody something. I don't need to tell you that I told my husband I'm going to go pick up Travis. I can just say I left the house to go pick up Travis and then explain what happened then. I don't need to tell you what I told someone. So no, you can't say it in court. She was trying to launder the hearsay, which I've never seen before. It was creative. Your Honor, it's not an out-of-court statement because hearsay is an out-of-court statement. It's not an out-of-court statement because she's in court now saying it. Wrong. Is Elaine just trying to constantly beat her personal best speed run of Return to Sidebar? Yes. With no cheating or anything. It was like a true speed run to Sidebars. See how much fun the Sidebars are? I have a headache. That didn't help. My nose still has issues. My nose is mad at me today. There were lots of motions for Vincent Van Gogh today. It's infuriating. Shout out to my best friend, Caitlin. We are watching from Italy while diamond painting. Shay, I love that. How much fun. If you post the diamond painting anywhere that you made, will you just tag me? Elaine, your mic, Emily. Emily, your mic, you're blowing your nose, your mic. I know. Elaine is like, see, it's not that easy to turn off your mic. It's goofy when you forget it. Good Lord. You know what would be fun to do? Have a live stream with some acting enthusiast members and do a reenactment of some of the sidebars. I don't know about that. I'm just going to go through them because if somebody was just acting them out, I couldn't interject all the legally legal things, I don't think. Emmy said, watching you help me recognize that there's no shame to get an ADHD evaluation. There is no shame to get an ADHD evaluation. I really think we should see all of our health as cohesive. I don't feel ashamed when I go have blood work done or take a flu test or whatever. And I'm not going to feel that way about mental health. I'm going to treat it the same as physical health. Like if I have a broken leg, I'm going to get that handled, right? So if my brain, not that ADHD is being broken, that's not the analogy, but if my brain is doing something different and I need help, then I'm going to ask and be like, hey, what's going on with this? Just like if I'm not sure if I have the flu or something else, I'm going to go ask, hey, I'm not sure what's going on with this. So I did it yesterday. Thank you. I'm in the Cool Kids Club. Welcome to the Cool Kids Club, Emmy. And I really think we need an attitude shift on health and just treating health as health, not like physical health, mental health, right? People treat their allergies. Why is it any different? Making sure that you understand your ADHD. Yes, we're going to have to do Dr. Spiegel too. I promised I would do the Spiegel sidebars. I do. We're going to have to do both of those. So congratulations, Emmy. I have missed your Elaine. Most important sidebar IMO is Morgan Tremaine subpoena after motion hearing. I will. I think we need to do Spiegel, cross-examination of Amber Heard, and yeah, Morgan Tremaine. And maybe both Morgans. We'll see how much time we have. Code Green needs an enhancement. I can do that. You have such an amazing work balance life. I don't know about that. I try. Elaine pledged to do a good job. She pledged to try. She's like, I pledged to get into that. Dr. Curry also will see. We want all the sidebars. I don't know if we can reread this whole trial. This is just further proof that Amber chose a garbage legal team. I don't know if she chose that. Some of this was chosen. Elaine seemed to be chosen, but this is also paid for through insurance. So I think the other legal team is probably like, I'm glad we're gone. That's fighting out in the insurance cases. Sarah, I'm so sorry about the loss of your paw nerd. He looked just like George. He was a hugger and shoulder biscuit maker and passed in my arms overnight. I'm sorry. Albus was 17 when she passed. It is a very, very difficult thing. George is not a hugger. He is not. He will come and sit on your on your lap, but he will not let you, like, even when I lift him up to show him to y'all, he doesn't want any part of it. And then he knocked over a cat or the cup and then he was out. Can we take a moment to recognize the mods? Chad is flying today. Not an easy job. They do a great job. But you know what? The mods do a fantastic job and are able to do a fantastic job because y'all are also fantastic, right? When the goal is to have a pleasant chat, everybody pitches in and the mods really help keep that on track. And it's incredible. Moist Critical did his first like YouTube stream and I don't know how long yesterday. And so I was watching some of the stream and I don't think he had any mods in chat, and he clearly streams on Twitch normally and was trying to figure out like the streaming settings on YouTube. And the stuff that was in the chat, people just trolling the chat. We have it locked down and it doesn't happen here anymore. And I'm so thankful for it because I forgot how bad it can get. And he seemed frustrated with the whole thing as well. Anna said, hopped on because I miss hearing you say Elaine. Give us one more. Turn your mic on, Elaine. I can't because I forgot to turn my mic off. Elaine, your mic. Amy said, thank you for being my body double as I deep clean my 3rd grade boy's bedroom as we get ready for school. You are welcome. I am always here to do the body doubling. It's always needed. Bring muffins for the court staff. Always bring muffins. Always bring muffins. Always. Unless they prefer something. Jay said, manager at Starbucks for 10 years. I can send recipes on making pumpkin faves all year. I just need to buy pumpkin spice bottles and use a frother. I have both of those things at my house. I do. Sophie said, I'm a court clerk in the UK and I will tell judge if people are rude so the judge admonishes them. Oh, absolutely. Always. And the judges want to know. I love the firsthand experience. Thank you, Sophie. Question, how is it possible the sidebar cannot be heard a few meters away where the plaintiff and defendant are sitting? Sometimes they can hear some of it. the people on the stand, but it doesn't matter as much if they hear it. The jury can't hear it because there is white noise in the courtroom that's piped in. Found camo, a new barn that is great for us. Thank you, EDB and Law Nerds. The good energy. Nick, I'm so excited. Congratulations on finding the new barn. I know that was causing a lot of stress last week. Will you please cover the Afro Man lawsuit? The cops are suing him for using surveillance footage from a raid in a music video. I will take a look, Scott. I have been hesitant to jump into new cases because I've been so behind, but I will absolutely take a look at where it's at and take a look at where it's at. It's a really interesting question. Who owns the rights? Is it likeness rights? I mean, it's on his property. Was there not a notice that you were being, I have questions. I will take a look. I have questions. Members, I love seeing all of your chats. 20-month members in Nashville this past weekend. No EDB sighting. I was not out and about a ton this past weekend. Apologies. Can I have a toast to my own paw nerd, George? To George! Rachel George. Yes, you absolutely can. It's members. I love that StreamYard lets me see these chats. You guys know that I'm a StreamYard ambassador and that I love streaming with StreamYard. I need YouTube to let us show you guys the gavels too. So I need to see all of that, but it's great seeing how long you guys have been members for. It's so much fun. It's so much fun. So thank you, Elizabeth, for being here. It's great, you guys. It's great to see it. For all of you that have been here for years, all of you that have been here for months, it's fantastic. Thank you. Petition for a Law Nerd meetup. I am working on it. It is on our team's mind. Don't worry. All of this sidebars made me decide I should just journeyman in my state because I could have done better than Elaine. I mean, it's not hard. Camille out here earning her partner promotion. These lawyers must have been so tired. It's a lot. Do we have a total number of times what if any was used in this trial? Oh God, no. The limit does not exist. The limit does not exist. Just got back from my ADHD evaluation in time to see this. Fingers crossed. I've been struggling on top of my autism. Rue, good luck with that. I hope you get the answers that you are looking for. It's fantastic. Stina said this one brought so many of us to you. It's special. It is. This case has a special place in this channel's, I don't know, growth and history and a lot of law nerds finding that what they wanted was trial commentary with curse words. Because of course we do. How do you get a membership? I know that the mods were talking about that in the chat. So good luck. Let's see. And then I've got to go. So y'all, just letting you know, I've got to go. Will you be covering the Michael Orr case? That is the podcast tomorrow. I put I put a YouTube short out on my shorts channel, Quick Bits. I put one on Instagram and I am covering it tomorrow. The members were there on the recording, Amanda, yesterday afternoon. That's what I recorded. So that's tomorrow's podcast. The rules of evidence, Elaine. I really did learn so much from you during this trial. You kicked off a bit of a law fascination. You're welcome. The rules. There are rules. You just have to play by the rules. You said you would do Spiegels. We have to do Spiegels. We have to. Terry said, being an EMT made me realize I really don't like to touch people. It's fair. It's fair, especially not in that sense. I get it. EDB channel is like home. My cat's name is Karen. That is tremendously kind. It feels like that for me too, getting to chat with y'all, and I love it. I have got to go, you guys. I have got to go pack and get ready for a very early morning tomorrow. I will be on social a bit. I will be traveling a bit. I appreciate all of you. Law Nerds, the podcast will premiere tomorrow. I'm going to try to be in the chat, but I also want to make sure you can be in the chat with each other because this case is wild, but I will be doing my best. It's going to depend on airplane Wi-Fi, honestly, but I will try to be in the live chat with you as much as I can. Just wanted to give you a heads up. Chat, you are the best. You are bae as always. For those of you that joined the channel today and subscribed today, thank you for doing the likey, subscribey things. I'm going to have to shift this so we can see the sub counter. I got all I've been redoing my desk. We'll get it sorted. And then I will be streaming on Friday. Sign up to Law Nerd Alerts so you know where to go. And I will see you around the interwebs. And then on Friday. And then next week, Next week, it looks like we might need to do another one of these. What do you guys think? It feels like we just need one more. We're just not done yet, right? We're not done with the sidebars? Fair enough. Because I saw that poll, 97% of you said yes. So away we go. All right, I'll see you guys soon. Bye.
You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at The Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits.